gotta get on YouTube.
Good morning, Your Honor. Mr. Curtis Harris, and I have a Tamika Gardner at 9 o'clock.
Actually, give me a couple.
Thank you.
Okay, we are on the record as the people of the state of Michigan versus Demetrius Sherman Ewing, 2356387. Mr. Ewing is charged with count 1, controlled substance, 3, manufactured methamphetamine, and count 2, firearms set for a probable cause competent.
They went to Milwaukee P548. People.
Good afternoon, Your Honor. Good afternoon to your staff. May it please this honorable court. My name is Todd Russell Perkins, P55623, appearing on behalf of Mr. Ewing. Mr. Ewing, can you announce yourself?
Yes, sir. My name is Demetrius Ewing.
Okay.
May I, Your Honor?
Yes, please.
Thank you. May it please the court. Your Honor, I have only received paper discovery. I believe there's video and audio discovery. I have not received that yet. I did make some efforts, and I was unaware of who I should contact directly. This is actually a case that doesn't find its inception within the Detroit Police Department. It's a, I believe it's the Sterling Heights Police Department task force that initiated this investigation. So I don't know what to do to get the discovery.
Your Honor, according to the investigative report, there is no visual.
Okay. Well, I would propose to provide a discovery order that asks to be signed. If I can get a brief adjournment of the PCC, I'll either drop off the discovery order or send it to the parties right now. It's my understanding that this was a collaborative effort, that maybe Sterling Heights did not have body cams, but there were body cams at this particular location.
Mrs. Watt, do you have any information about that?
No, we don't. Like I said, according to our investigators report, there is none visual video.
Okay, so you can send a discovery order over the probable, the PE was scheduled for the 15th. I'll adjourn that for another PCC.
Can I have, Your Honor, may I have your prosecutor's email address? Because I would want to copy him or include him in any email communication with the court.
Who should I send it to? Who should I? Which email?
You can send it to me. And I'll forward it.
EFLWOCKI.
Yeah. Excuse me.
Okay, I just sent it.
Okay, thank you.
So 8:30 on May 15th.
Thank you so much, Your Honor.
You're welcome.
All right.
Is there an attorney present for Daryl Williams?
Yes.
The attorney present for Daryl Williams.
Yes. What?
I
Oh,
said
no.
the attorney present.
No, I don't know.
That's why I'm asking. If you're not an attorney, then there would be no response for you. If the attorneys who are from NDS or any attorneys, could you all please identify who you're here for? Did not already do that on their icon.
Good morning, Your Honor. This is Attorney Greg Sheen. I'm here for Mr. Hill.
Good morning, Your Honor. Hugh Marshall. I'm here for Dante Stewart. He was in the hospital, and I don't know if he's still in the hospital or not.
Good morning, Catherine O'Meara for Marcus Ross.
Good morning, Your Honor. Sophia Nelson of NDS for Dion Watson.
Thank you. All right, any attorneys ready with their client?
Oh, actually, say this was since the 2013.
Your Honor, I'm ready to proceed. We have not been able to locate Mr. Watson. This is an adjourned PCC to allow us the opportunity to try to make contact with him, and we've been unsuccessful.
Okay. On the record, this is people of the state of Michigan versus Daryl. That's the right person. Dion Watson. Dion William Watson. 2305652101. Charged with count 1, weapons, firearms possession by felons. Count 2, weapons, ammunition possession by felons. Count 3, weapons carrying concealed. Count 4 and 5, weapons, felony firearm. For an adjourned PCC appearances.
Edwin Milwaukee, P5488.
Good morning, Your Honor. Sophia Nelson of Neighborhood Defender Service on behalf of Mr. Watson.
And as you stated off the record, Attorney Nelson has been able to contact your client, correct?
Yeah, I have had no contact with him, Your Honor.
Anything from people?
People would ask the gentleman be curious.
Okay, I did allow for some time for Attorney Nelson to try to find Mr. Nelson, excuse me, Mr. Watson, I keep forgetting that name today. Because he's still not present, I am going to issue a case. It will be $1,000 personal.
Thank you, Your Honor.
You're welcome. You have a good week.
You too.
Your Honor, your client is appearing in a matter of Darius Boyd. This is the case so that the people cannot find the case. Unfortunately, he's been extradited to Jackson, Michigan. I would respectfully ask to waive his presence as I believe this matter was going to be nolly prosecuted.
Okay, if you could just give us till 9 o'clock, I want to handle the PCCs first.
Thank you, Your Honor.
Good morning, Judge Mustafa Hawili. We're here for an adjourned PCC, Your Honor, and we were unable to locate Haskell.
Okay. Don't let mother. No. On you. Okay, Casio, and then he'll. Okay, Dwayne Kirsten Casio, case 2258287, the people of the state of Michigan versus Dwayne Kirsten McCaskill, charged with count 1, weapons carrying concealed. Count 2, police officer assaulting, resisting, and obstructing. Count 3, weapons holding firearms set for probable cause count appearances.
Edwin Milwaukee, P5488, appearing on behalf of the people.
Good morning, Your Honor. Mustafa Hawili, P number 83817 on behalf of Dwayne McCaskill.
And your client is not present, correct?
No, Your Honor. Our office has sent multiple letters to his home as well as tried calling him multiple times. We have not had any response in the last PCC.
Okay, anything from the people?
people would ask that the gentleman be taken.
Okay, we did allow for an adjournment so that he could be found. There was also a case on August 18th of 22, so it'll be $1,000 cash surety.
Thank you, Judge.
Thank you. Have a good week.
You too. Bye-bye.
Thank you.
Party's ready on Juwan Hill.
Hi, Your Honor. If I can speak with the prosecutor for a second.
Sure. The prosecutor is in the courtroom, not on Zoom. Unless it's a special prosecutor on the case.
I don't think it's a special prosecutor, but I'm not 100% sure.
I didn't hear you.
But we're not aware of that.
Okay, so it's a little difficult to speak to him right now. He's in the courtroom.
Oh, can I get either a phone number or email, and then maybe we can just request an adjournment and I can reach out to them?
Just give us a moment. Let me clear out some of these cases before I do an adjournment.
Okay, thank you, Your Honor.
I'll give you the email address in the meantime.
Thank you.
Attorney Tucker, ready on your case?
Excuse me, Your Honor, what'd you say?
Just wondering if you're ready.
Yes, Your Honor.
Okay. This is People of the State of Michigan versus Artiste Paul Griffin, case 2356412. Mr. Griffin is charged on this case with count 1, assault with a dangerous weapon, felonious assault, count 2, weapons, felony firearms, set for a probable cause conference today. Appearances.
Everyone's Milwaukee, P5438, here on behalf of the people.
Good morning, Your Honor. Tamika Tucker, PA 5402, on behalf of Artiste Griffin, who's present via Zoom.
Mr. Griffin, can you state your full name for the record, please?
You have to unmute, Mr. Griffin.
Your Honor, my name is Artist Paul Griffin III.
Good morning. Attorney Tucker, are you the retained attorney?
No, Your Honor, I am still the court-appointed attorney. It looks like he has not retained an attorney, so we're going to set this for a preliminary examination.
Okay. You have discovery, correct?
Correct, Your Honor.
Okay.
We still need digital discovery. If there's any at all.
We'll look into that.
Thank you.
Okay, so does May 15th work?
May. Let me look and see, Your Honor. Yes, it does.
Okay, how about 9 o'clock?
9 a.m.?
Yes.
Okay, that works for me.
Okay, Mr. Griffin, your exam has been set for an in-person preliminary exam for May 15th at 9 o'clock a.m., 36th District Court. Understand?
Yes, ma'am.
Okay, anything else from either party?
No, Your Honor.
No, Your Honor, that's it.
Okay, you have a good week.
You too.
Okay, Mr. Attorney McCoy, your client is present.
Good morning, Your Honor. Wayne County Jail.
Good morning, how you doing today?
Good.
Attorney McCoy, did you speak to your client before we go on the record?
I'm sorry.
I was asking if Mr. Stewart's attorney needs to speak to him in private before we go on the record. Attorney McCoy, you're on mute.
Morning, Your Honor. Al McCoy on behalf of the defendant P38666.
Speak to your client before we go on the record.
Yes, Your Honor. Hello, Demetrius?
Yes, I'm here.
What's going on? Are you all right?
Yeah, I'm all right. Was it just me and you speaking?
Everything's set. You know what we're gonna talk about?
You're not in the breakout room anymore.
Oh, I'm sorry, Your Honor. We're all set, I guess.
He's still in the breakout room. You can go back in there.
All right. I'm not sure how to get there from what I'm looking at, Your Honor. Nothing on my screen.
It's on the toolbar. You have to go find it after the first invitation.
Toolbar.
It's just say go to breakout room. Or
Yeah.
breakout room.
Nope. Not finding it yet.
There, I sent you an invitation, so you should be able to go in. Mr. French, go ahead and unmute your device. Is Mr. McCoy as well? Hello, Mr. French?
Yes.
Is Mr. McCoy your attorney as well?
Yes, ma'am.
He did not say that, so make sure, I'll make sure to say that when he comes back in the room.
Yes, Your Honor.
Okay. Harris first, or you?
No, I'm ready for Harris.
Okay, we're on the record with the people of the state of Michigan versus Curtis Harris, case 2355549. Mr. Harris is charged with count 1, attempted home invasion, 3rd degree, as defendant number 2, with also a habitual offender 4th offense notice set for a probable cause conference. Harris.
Edwin Zawaki, P5488, here on behalf of the people.
Good morning, Your Honor. Jabari from P81745 on behalf of Mr. Curtis Harris. Your Honor, unfortunately, I have not had contact with Mr. Harris. I have made several attempts at the address and phone number, but today I've been unable to locate or contact Mr. Harris.
We asked that this gentleman be indicated.
He gave this on March 1st for his exam, and I did issue a $1,000 personal, so it's going to be 2,000 cash surety. Yeah. If you find them, you can bring them in for it to be arranged.
We also want Tamika Gardner for preliminary examination.
Okay, well, let's call it. All right. So they have a seat here 30. All right. Attorney O'Meara, we're getting ready to go on the record for dismissal, but your client is being let in. You need to speak to him before we go on the record.
No.
Okay, this is the people of the state of Michigan versus Tamika Ann Gardner, case 2356214. Ms. Gardner is charged with one kind of weapon carrying concealed set for preliminary examination. Set appearances.
Edwin Milwaukee, P5482A, appearing on behalf of the people.
Good morning, Your Honor. Brian Crimpay, P81745, on behalf of Ms. Tamika Gardner, who is present in the courtroom to my right. Ms. Gardner, please state your name for the record.
Tamika Gardner. Hey, are we ready to proceed?
No, Your Honor, unfortunately, we are missing central witness.
Your Honor, therefore, the defense is respectfully requesting a dismissal of this matter.
Okay, the people are not ready to move forward. They set for an exam. I will see you without questions. We're all set. Anything else on the record?
Sure.
Okay, I have it. You go ahead. Thank you. And doesn't matter, you want to.
Oh, you got a copy of the order on that?
Yeah, I thought you had another case.
Oh, no, that's it. Thank you very much, Your Honor.
You're welcome. Okay, Attorney O'Meara.
Ready?
People of the state of Michigan versus Marcus Darren Ross, case 23056432202. Ross is defendant number 2 and charged with one kind of stolen property, receiving and concealing a motor vehicle, set for a probable cause purpose. Appearances.
Edwin Milwaukee, P5482A, appearing on behalf of the people.
Good morning, Your Honor. Catherine O'Meara, P53823 on behalf of Mr. Ross.
Mr. Ross, can you state your full name for the record, please?
It looks like he's connecting to audio.
Okay.
We're just setting the preliminary exam date. So.
Okay. The date I have here is for May 15th or May 16th?
I don't, both of those dates are bad for me. I could do the 17th.
Okay, that's fine. Let me see what time. 9 o'clock?
9 o'clock is fine, yes.
Okay, May 17th at 9 o'clock. Make sure you let your client know I'll waive his presence as he is here, but audio is not connected.
Thank you, Your Honor.
You're welcome. Have a good week.
You too.
Ready on Stewart? Are we ready on Stewart?
Yes, Judge, the people are ready.
Okay, let me get the defense attorney on the break over. Thank you. Okay, we're on the record. This is people of the state of Michigan versus Dante Stewart, charge on case 2355998 with count 1, weapons carrying concealed, count 2, police officer assaulting, resisting, and obstructing, count 3, weapons felony firearm. Mr. Stewart is also charged on case 2355990 with count 1, police officer fleeing third-degree vehicle code, count 2, stolen property, receiving and concealing a motor vehicle, also set for a probable cause conference. Appearances.
Good morning, Your Honor, to your staff. On behalf of people 362243.
Good morning, Your Honor. Dante Stewart.
Good morning, sir. And Attorney McCoy.
Yes, Your Honor, I'm here, but that's not my client.
I think Mr. Hugh Marshall, defense attorney on this case. I thought I saw him.
And Attorney McCoy, who were you in the breakout room this whole time with?
With Mr. Stewart, but he is my client.
I'm sorry, can you say that again?
I'm on the case of Demetrius French, Your Honor, not Stewart.
Okay, so that was. Okay. I will recall Stewart when his attorney appears. Calling case 2356316, People State of Michigan versus Demetrius French, charged with count 1, weapons, firearms, possession by felon, count 2, weapons, ammunition, possession by felon, count 3, weapons, carrying concealed, count 4, weapons, felony firearm, second offense, count 5, weapons, felony firearm, second offense, with the official offender third offense. Notice that for probable cause conference. Appearances.
Edward Sawaki, P5482, appearing on behalf of people.
Alan McCoy, 38666, appearing for Mr. French.
Mr. French, can you state your name, please?
Yes, Your Honor. Demetrius Anthony French.
You have discovery, Attorney McCoy?
I got the paper discovery, but I think there's some camera discovery that I don't have body cam. And I'd like to have it.
Yeah, digital, Your Honor, was also sent on May 5th. It's a link.
The people sent it on May 5th.
All right, Your Honor, I didn't see it, but I'll check again.
If you don't find it, please email me and resend it.
All right. I'm not sure how to get to it while we're still here, Your Honor.
Okay, I will send you in the chat his email address if you still need to email him to resend it.
All right, thank you.
Okay, can you do May 15th?
May the 15th, yes.
Okay, let me get you a time. $10 o'clock?
10 o'clock is fine, Your Honor.
Okay. Mr. French, your exam has been set for an in-person preliminary examination, May 15th at 10 o'clock a.m. Understood?
Yes, Your Honor.
Okay, and I'm going to send over the email address of the prosecutor, Attorney McCoy, so you can email him if you need to.
Thank you, Your Honor.
You're welcome. Anything else from either party?
No, Your Honor.
No, Your Honor.
Okay, well, have a good week.
You too.
Okay, back to Attorney Lyons.
Good morning, Your Honor.
Good morning. All right, this is People of the State of Michigan versus Darius Duran Boyd, case 13059900001. Okay, Mr. Boyd is charged with 1 count of weapons carried concealed, count 2 weapons, firearms, possession by felon, count 3 weapons, felony firearm with an official offender, 3rd offense notice set for preliminary exam today.
Anyone to walk in P54828, hearing we have people.
May it please the court, George Lyons, P55475, on behalf of the defendant, Mr. Boyd.
Okay, and Attorney Lyons, you stated off the record that your client is currently where?
Apparently, Your Honor, he was on probation in Jackson County, and this matter is a violation, I suspect. So they came and got him yesterday. I got a call from the family, and I confirmed it with the court up here. But I would certainly waive his presence down there, as this is a 10-year-old case, and the people don't have a file.
That's true. It's a 10-year-old case, we don't have a file. It doesn't look like we're going to be able to find UIC and here.
Okay. I will waive his presence, as this has been discussed prior to today via email. All the parties are on the same page. If you were present, it would be no different. So people could move forward. So I will dismiss without question.
Thank you, Your Honor. You guys have a great week.
You as well. Thank you. Mr. Ross.
Yes.
Your case was already called. Are you waiting for something?
No.
Did you get a court date?
No, I didn't get the court date.
Did you hear anything?
Huh?
Did you hear anything? Your lawyer? Did you listen at all?
Miss O'Meara is my lawyer. Okay.
Okay, what?
You gave me a court date, right?
I'm asking you, did you hear anything that we discussed?
No.
You have your attorney's phone number?
Yes.
Can you call her, please?
Okay. I'm about to right now.
Have a good day.
You too.
Good morning.
Good morning, Your Honor. My client's wife just contacted me and let me know that he is still not been prepared for the Zoom hearing today. Last we spoke, there was supposed to have been a writ to STS that he was supposed to appear. So if someone could just call the warden's assistant and let them know that we do have this Zoom hearing today.
Okay, it was sent on Friday. I will have to start. Mr. Eric Jordan. Mr. Eric Jordan, unmute your device, please. I believe you have a traffic matters, is that correct? I'm gonna log you off, Mr. Jordan, you're in the wrong courtroom. If you don't respond, I can't help you.
Say that again, ma'am. I'm sorry.
Yes, what are you here for today?
This is my first court day for me being released from jail. They told me to come to this courtroom.
What type of court case are you here for today, sir?
It's a gun case.
Okay, you have a case number.
Say that one more time, ma'am.
You have notification, you have a case number on that notification.
Hold on 1 second. I can see if it's in the paperwork, but it didn't give me any case number. It says find courtroom 438 / Judge Aliyah Sabree.
Yeah,
Click
that's where
join
you are.
Zoom
I'm
area.
trying to see why you're here. You're not on the docket, sir. What's your middle name?
Sheldon.
Okay, give me a moment. What year were you born? Don't say your whole birthday.
94.
Tomorrow at 8:30 for probable cause. Okay, you're a day early, Mr. Jordan, tomorrow, 8:30.
Okay. Okay, yes, ma'am.
All right, have a good one.
You too.
We ready on Hill? Juwan Hill?
Hi, Your Honor. I did email to the APA, Mr.
That's right.
Solwaki. I did send over an email if he wants to just check that and maybe respond, or I mean, we can request an adjournment today to give him time to respond.
Let me handle, let's see, one more PCC, then he might have a little time to address it. Attorney Castro, who are you here for today? Good morning.
Good morning, Your Honor. I'm here on Daryl Williams.
Okay, Mr. Williams. You've been here waiting and taking a little nap, I think. Following case 2356353, People of State of Michigan versus Daryl Williams, charged with count 1, weapons, firearms, discharge, in or out of building. Count 2, weapons, firearms, possession by a felon. Count 3, weapons, felony, firearms, second offense notice. Count 4, felony firearms, second offense notice with an habitual offender, fourth offense notice set for a probable cause conference. The appearances.
Everyone to walk P5483 on behalf of people.
Good morning, Your Honor. Nancy Castor from Neighborhood Defender Service of Detroit, appearing on behalf of Mr. Daryl Williams, P number 80549.
Mr. Williams, can you unmute your device, please, and state your full name for the record? Your device is muted.
Judge, Mr. Williams, can you unmute your device?
Can you hear me now?
I
Can you hear me now?
I
Okay,
can. Good morning, sir.
good morning.
Can you state your
My
name,
name-
please?
Yes, Daryl B. Troy Williams.
Thank you. Attorney Cathcart, you have discovery.
Your Honor, I am in receipt of paper discovery. I don't have any of the digital discovery. I just request that it be sent over as soon as possible if there is.
Okay. We'll do that.
And Your Honor,
Okay.
if we can schedule this matter for a preliminary examination, please.
May 15th, does 10:30 work?
10:30?
Yes.
Yes, that's fine.
Okay, Mr. Williams, your
Yeah.
preliminary is set for an in-person exam at 36th District Court for May 15th at 10:30 a.m., okay?
Okay. I have to be there in person?
Yes, you have to be in person, Mr. Williams.
Okay,
All right, I will see you next Monday.
all right, thank you.
You're welcome. Have a good week.
You too.
Thank you, Your Honor.
Okay, so we are done with Judge Sabree, just, Attorney Marshall's not signed, he said he's signing it right now. All right, this is the special prosecutor case for Mark. So, Attorney Sheena, Mr. Sawaki has a moment here, he can look at your email while we call you the case.
I'm sorry, Judge, I didn't get that.
This is a special prosecutor case, so Mr. Sawaki has a moment to look at your email now.
Okay, thank you.
Okay. This is People of the State of Michigan versus Dante Stewart. Case 2355998. Mr. Stewart is charged on this case with weapons carrying concealed. Count 2, police officer assaulting, resisting, and obstructing. Count 3, weapons on firearm. Mr. Stewart is also charged on case 2355990 with count 1, police officer fleeing third-degree vehicle code. Count 2, stolen property, receiving and concealing a motor vehicle. Set for a probable cause conference for both cases. Appearances.
Good morning, Your Honor, to your staff. Veronica Dean on behalf of the people, P62243.
And good morning, Your Honor, Hugh Marshall, P48269, on behalf of Mr. Dante Stewart, who I see at the Wayne County Jail. Consent to Zoom for today's hearing.
Good morning,
Your Honor. Dante Stewart.
With the right attorney, good morning. Okay. And this was adjourned because Mr. Stewart was in the hospital last time we were here, correct?
That's correct.
Are we ready to move forward with an exam date?
Yeah.
Okay. Yeah, you can look it up. Okay. How about 11 o'clock for both cases?
On what?
I'm sorry, May 15th.
That's good for the people.
What date, Your Honor?
May 15th.
I'm in an all-day trial. I could do the 18th. Oh, no, I can't do that either. Sorry. How about the 22nd, Judge? I'm wide open.
I'm off that day, and I don't know if I want someone else back to come.
I'm sorry?
I'm off that day.
Oh.
Wednesday, Tuesday. On 24th is the next available date. You can't do. Can't do anything the week of the 15th. You can't do that 15th, 16th, or 17th, right?
Right. 15, 16, 17, trial. I could do the afternoon of the 18th.
All of the judges are in training, 18th and 19th. I would like to, but we're gonna be gone.
I could make the 24th work.
Okay, does that work for the people?
Yes, Judge.
Okay, let's see. We can go first, 9 o'clock. You like that?
Sure.
That's fine.
All right, May 24th at 9 o'clock for both cases. All right, anything else?
Just the issue regarding bond. I haven't had a chance to speak to Mr. Stewart. I don't know what his current bond is, and whatever it is, he's still in the Wayne County Jail. So I asked for some sort of reduction in order for him to be out and assist me in preparing for this exam.
Your Honor,
25,000. I'm sorry, go ahead.
Your Honor, the defendant came in front of you twice for 2 PCCs. I think someone was standing in for you at the time. Judge King ultimately set his bonds on both cases, 5,000 cash. When he was arraigned on his warrants, he was given the same bonds, but a tether requirement was added at my request, and I can explain why. And then when went in front of Judge McConico for the bond redetermination hearing, he set one of the cases at a personal bond, 25,000 cash personal, and the other one at 25,000, 10%. So his bond is 2,500 with the added element of a GPS tether. The GPS tether that people had requested, because between the time of these incidences and him getting charged, he was posting himself on social media with firearms, doing, donuts in residential areas, also having a firearm in a vehicle. He has a complete disregard for the law and the safety of others. And so I'm asking that his bond remain the same. I didn't hear you, Judge.
I just said anything from Attorney Marshall.
Yes, well, as the court knows, there's 2 determinations to be made for bond. One is whether or not he will show up for court. I understand there's a history of capias, and the other one is he's a danger to the community. The prosecutor has made, I'll admit, a compelling case, but nonetheless, a reduction in bond. If you could post that, and if he doesn't show up, you'll have another capias. I think he's smart enough to know that he'd be in big, huge trouble if he doesn't show up.
I'm going to leave on as is, blow it up. Judge McConico changed it to 25,000, 10%. People have given me more than enough to leave it where it is. So that's where we'll stay.
Okay, Judge.
All right.
Thank you.
Take care.
Okay, Attorney Sheena, anything?
Yes, hi, Your Honor. We're ready now.
Great, that's what I was hoping. I did not want to adjourn. Okay. Calling case 2356434, the people of the state of Michigan versus Jawan Hill. Mr. Hill is charged with count 1, controlled substance, delivering, manufacturing marijuana. Count 2, weapons, felony firearms, set for a probable cause, count 6 appearances.
Everyone's a walkie P548.
Good morning, Your Honor. Attorney Gregory Sheena, P 74815, on behalf of the defendant who's here via Zoom, consents to being on the Zoom call today. Your Honor, we would like to request an exam date, and I do apologize, that May 15th date is not going to work for us.
Okay. Okay, let's see. You said the 15th doesn't work.
No, Your Honor. And are they just Mondays or any day of the week?
No, I'm just trying to stay within our time frame, 5 to 7 days. So, they're every day, but next week, only the 15th, 16th, 17th, because we're out in training that Thursday and Friday. So the
Okay.
16th.
He did waive that 21-day rule, and I'll be honest, Your Honor, my whole month of May is pretty full, and I would like to request a June date if that's okay with the court.
It's not just about you all, it's also the court docket trying to keep things within.
No, I completely understand.
But I mean, if you can't make it work at all.
Your Honor, my schedule is really jammed up the whole month of May.
Okay, so June 1st, June 2nd,
June 2nd, Your Honor, works wonderful, if that works okay with the court.
okay, 9 o'clock.
Thank you, Your Honor. And that's in person.
That's in person, Mr. Hill. Mr. Hill, unmute your device, please.
How you doing?
I'm fine. How are you?
I'm good.
Okay, so your exam has been set for an in-person preliminary exam at 36th District Court on June 2nd at 9 o'clock a.m. Understood?
Okay.
All right, anything else from either party?
Nothing further, Your Honor. Thank you.
So have a good week. Checking on Mr.
I never checked in. I'm the prosecutor. I'm McClinton.
Oh, okay.
Brendan Sawyer.
Oh, Mr. Sawyer.
Morning, Judge.
Yeah, we can restart exam, so it's 30 minutes.
Mr. Already back.
Okay.
All right, I'll try.
Shayla Jones. Shayla Jones.
Yes,
Good morning.
good morning.
Are you here for a traffic matter, Ms. Jones?
No, I'm just here observing.
Okay, you have to observe on YouTube, not in the actual meeting room.
Got it. Okay, thanks.
You go on the website, 36th District Court, and click on courtroom for create.
Got it. Okay, thanks.
You are.
Oh.
Let me check. I don't have familiar like we did.
Which one?
We did it.
Oh, sure. Oh, I got you. Sure.
Yeah.
I don't think I've got it.
No. Evan is in St. Louis. They do not. Mr. Sulaka?
Yes, Your Honor.
Okay, once again, somehow was not received Zoom writ. He is in church right now. Person's on the phone talking with the person who is going to make sure he gets on Zoom. I told them to have him on before 11 o'clock. So if you want us to just call you when they log on.
Yeah, that's fine. I mean, I'll plan on being on at 11 if that makes the most sense for you, Your Honor. I'm sorry, I said I can just plan on being on at 11 if that makes the most sense for you.
That's fine. Yep.
Okay. All right. Thank you, Your Honor.
All right, thank you. Okay. Everybody ready on the record? This is people of the state of Michigan versus Aaron Leviticus McClinton. Case 2305653. Mr. McClinton is charged with count 1, assault with intent to murder, count 2, assault with intent to break by harm less than murder or by strangulation, count 3, weapons securing concealed, count 4, assault with dangerous weapon, felonious assault, count 5, police officer assaulting, resisting, and obstructing, count 6, 7, 8, and 9, weapons felony firearm, set for a preliminary examination of the appearances.
Good morning, Your Honor. Brendan Sawyer for the People, P83033.
Hey, good morning, Your Honor. May it please the on court, Cody Betty back, P number 48117. Appearing on behalf of my client, who stands to the right, Aaron McClinton.
Mr. McClinton, can you state your full name, please?
Good morning, Your Honor. Aaron McClinton.
Good morning. Okay, then we're ready to proceed.
Yes, sir.
Yes, Your Honor. I just asked for a mutual order of sequestration with an exception for my officer in charge, the Deputy Barricade.
The objection to the officer charged.
No, no.
There's anyone on YouTube or Zoom who may be watching, who may be a potential witness, now their time to log off and smart in the courtroom. With the exception of OIC, there's no one else present who should not be here other than staff and attorney. Thank you for your presence.
Thank you, Your Honor. This time, the people would call Officer Mark.
Hold that. Might be your last out. Now you're ready.
Thank you, Your Honor. Good morning, sir. Could you please state your name for the record?
Thomas Martin.
And Mr. Martin, how are you employed?
I work for the city of Detroit for the police department.
And how long have you worked for the city of Detroit Police Department?
About a year and a half.
And are you currently assigned to any particular location or task?
The 12th precinct.
And are you just a patrol officer in the 12th precinct?
Yes, sir.
And were you working in that capacity back on April 15th, 2023?
I'm sorry?
I'm going to take you back to April 15th, 2023. You were still a police officer in Detroit?
Correct.
All right. And were you working in the 12th precinct on that day?
No, I was not.
What was did you have a different assignment on that day?
Yes, I was the strike force unit that day, so I was called out to go downtown for extra manpower.
And do you remember what time that was?
Yeah, that was about at 9:30.
Is that in the morning or the evening?
Yeah.
And you just mentioned something called the strike task force, is that correct?
That's correct.
What is that?
For each shift, for each precinct, there's one unit assigned to the strike force unit. And if anything happens in the city where they need extra manpower, those units are first to go and assist.
And Back around 9:30 PM on April 15th, were you working alone, with a partner, with a group of officers? What are we talking here?
I was with a partner.
And who was that partner?
That was Officer Nathan Lavelle.
And did you come at some point to a location at Randolph Street and Cadillac Square?
Yes, I did.
Is that in the city of Detroit, County Wayne?
Yes, sir.
All right, and what were you doing at that location?
I was just there for officer presence, keep peace, make sure citizens were safe.
And around that time, did something occur that brings you to court here today?
Yes,
What was that?
a large fight broke out.
When you say large fight, can you sort of describe that for us?
Yeah, there was about 20, 25 individuals. Everyone was fighting, hitting each other, kind of running around in between Bates and Randolph Street on Cadillac Square Park. I think it's Cadillac Park.
And could you determine whether any of these 20 or 25 people that you mentioned were together, separate, anything like that?
No, I did not.
Okay. And what happened after you sort of observed this fight right now?
During the fight, I saw the defendant produce a handgun and fire a single shot.
And sir, you say you saw a defendant produce a handgun. Did you know that person at that time?
I did not.
And how far away were you from that person when you saw them produce a handgun?
About 100 feet.
100 feet?
Yes, sir.
Do you see that person here in the courtroom today?
I do.
Could you point to him and identify him by an article of clothing?
I mean, he's right there. That night, he was wearing a white and black shirt.
But could you just describe what he's wearing today if you see that person here in court?
Yeah, he's wearing all green, brown slides.
Your Honor, I'd ask that the record reflect the witness's identification of Mr. McClendon. So, Officer Martin, when you first saw him from about 100 feet away, what did you do next?
I ordered him to stop.
And at any point during this, did you get closer to him, farther away? What are we talking?
Yeah, well, I was starting to approach him as I ordered him to stop. And as I got closer to him, he started to run away from me.
How close were you to Mr. McClinton when he started to run?
Probably about 30 feet.
And did you see where Mr. McClinton produced the firearm from?
I did not.
And at the time that you got about 30 feet from him, were there other people around?
Yes, sir.
Was it roughly still the same 20 to 25 people, more or less?
Less, because after the shot was fired, everyone started to scatter.
And how many shots did you hear?
Just one.
And did you see anyone else at that location with a firearm?
I did not.
So you just testified that you got at one point about 30 feet from Mr. McClinton. What happened at that point?
Mr. McClinton began to run away from me. I chased him for about 60 seconds. He threw the handgun down onto the ground. Immediately afterwards, slipped and fell. I recovered the weapon and arrested him.
And while you were chasing him, for a portion of that 60 seconds, did he have the handgun in his hand or?
No, not that I can see.
And while you were chasing him, what, if anything, were you saying?
I was repeating for him to stop.
Do you remember what kind of firearm it was you recovered, sir?
It was a Glock. May have been a 42, I'm not sure.
After you were involved in this, did you generate a report?
I did.
And is that something you would document it in your report?
Yes, it is.
All right, would you refresh your recollection to take a look at that?
It would.
I think I've got it there, so you can just take a peek at it and flip it over once your memory's refreshed.
Actually, I don't have it in the report that I did. It's in the main report. This is a supplement.
It was a Glock handgun?
Yeah.
And you testified that you arrested Mr. McClinton?
Yes,
Did he have a holster with him?
he did not.
And at any point, could you tell when you saw Mr. McClinton produce the firearm where it was pointed?
I could not.
No further questions, Your Honor.
Thank you. All right, Officer, you're part of a special task force, is that correct?
Yes, sir.
And this was a night about 11:30?
Yes, sir.
All right, so there's maybe 100 people out there that night on that street?
Yes, sir.
And you say you saw 20 people made involved in the fight?
Yes, sir.
And you know how many people were associated with my client?
I do not.
Did you review any videos of this? Case?
No.
All right, and you said you thought you saw my client shoot. Did he shoot into the ground? Did you put that in the report?
I did not.
You didn't see where he shot.
Correct.
You think you saw him shoot? You saw his fingers? Finger pulled out?
I saw him holding the gun in the muzzle flash.
And was anybody else shooting that night?
Yes.
And you know who that person was and if he was arrested that night?
There were several people arrested and shooting that night.
Okay. But as, can I approach the honor with a map that I hope to make exhibit, was it A?
Yeah.
This purports to be the intersection downtown, in the place in question. Is that, do you need a pen to put down where you were when you recovered the gun?
I'm sorry.
Where you recovered the gun, what street you were at, location?
Yeah, it was Bates and Cadillac Square.
Just put, you know, your first initial. Might not be able to see Bates.
Yeah, I'm not familiar with the downtown area.
Okay, all right, so 7-Eleven, you've been in the area of the 7-Eleven?
Yeah,
Across from the old city county building?
that I'm not sure, but the 7-Eleven was right at Randolph and Cadillac Square.
Okay, is that where you guys were?
When I recovered the weapon, we were at Bates and Cadillac Square in a parking lot on the opposite side of this where 7-Eleven is.
So how many feet from 7-Eleven?
From 7-Eleven? 300.
Okay, and, okay, so you recovered the gun. Anybody else did you arrest?
No,
All right, now you said it was a second shooting. Do you know on that map where that was?
I do not.
Would you put your initial on that?
I didn't because I'm not sure what Bates is.
Okay. All right, we got it. So there was a big melee, is that correct?
I'm sorry?
Would you agree it was a big chaotic situation?
Yes,
And it was not daytime, it was nighttime,
correct.
and you only had the streetlights give you illumination.
Correct.
Now, did you recover any shells from the weapon?
I did not.
Did you review any video cameras?
No,
Not from Rock Financial cameras?
no,
Your body cam?
No.
And your partner's body cam?
no.
So could you tell the judge what group was the larger group that my client, what size group was he involved?
I couldn't differentiate individual groups within the group that was fighting.
So everybody was just wearing regular clothes, no red versus black, or just general civilian clothes?
Correct.
And can you say that he was by himself?
I could not.
And you said there was another shooting. Do you know how many shots were fired then?
Well, there were several shootings.
Within that vicinity, within the block?
Yeah, I couldn't say for sure, but 4 or 5.
Okay.
This was, as I had, attended your line.
Okay, you heard more shooting?
Correct.
All right. That was, you heard those shots after he's been arrested?
Yes.
Okay. All right. No further questions.
Officer Martin, you asked some sort of questions there about the lighting and sort of seeing that night. Do you recall if the roads were open, closed, anything like that?
Yeah, they were closed.
Closed to vehicular traffic?
Yeah, correct.
And you were asked questions about any other shootings, maybe a little bit broad. Are you aware of where in the whole city of Detroit any of those other shootings were?
No.
At the time that you sort of saw the muzzle flash, that was the only sort of gunshot you heard within that sort of narrow limit of time. Is that accurate?
That's accurate.
No further questions, Your Honor.
Thank you.
Yeah, at this time, people are going to call Detective Bearcat. Oh, excuse me.
That's last name.
Thank you, Your Honor. Good morning, sir. Can you please introduce yourself to the court?
Good morning. First name, Mohammed, last name, Bearcat, Detective, City of Detroit.
How long have you been employed with the city of Detroit?
Over 6 years.
And do you currently have any particular assignment?
I'm at the 3rd Precinct, Detective Bureau, non-fatal shooting.
And 3rd Precinct, what part of the city roughly does it cover?
We cover the downtown area, the surrounding downtown area, casinos, Wayne State University, and a portion of the 3rd Precinct as well.
And as a detective, the non-fatal shooting team in the 3rd Precinct, did you come to be involved in an investigation of a non-fatal shooting downtown back on April 15, 2023?
Yes.
What was your role in that investigation?
I was recalled. I was already in the downtown area investigating several other shootings that were occurring that night.
And at some point that evening, did you come into a contact with a Mr. Aaron Clinton?
That night, no.
The next day?
The next day when I went to, either the next day or the day after when I went to interrogate Mr. Clinton at the Detroit Convention Center.
And what was your role in this investigation?
I was the officer in charge.
And as a detective with the non-fatal shooting team there, have you performed interrogations before?
Yes.
All right. And is there a particular policy or procedure you follow when doing so?
It's recorded, and we're aware of the defendant's Miranda rights.
And do you advise them of their rights before you interrogate them?
Yes.
All right. And is there a particular way you go about doing that?
I make sure that they are able to demonstrate that they can read and understand by having them read the first portion of the Miranda rights out loud and ask them that they do understand it. If they do have any questions, that they let me know and I can clarify the rights for them.
And did you do that for Mr. McClinton?
I believe so, yes.
And is there any way you document Mr. McClinton's agreement to those rights and his awareness of those rights?
It's on a department form that indicates the rights Mr. McClinton would then initial and sign that he understood his rights.
And Mr. McClinton in fact did so in this case?
Yes.
And after being advised of those rights, did he agree to provide you with a statement?
Yes.
Permission to approach the witness, Your Honor? Yes. With whether people's proposed exhibits 1 and 2 also provided to Mr. Eddieback. So I'm going to have you just take a look at those. You recognize both of those things that I've handed you?
Yes, I do.
What do you recognize in this, sir?
As the constitutional rights that Mr. McClinton would have read and signed, as well as has my signature on there. And then the second portion, which is marked Exhibit 2, is the question and answer format.
And the question and answer format, what is that?
That is during the interrogation, I would ask the defendant questions, I'd write the questions, and I'd write the defendant's answers down as accurately as possible.
And after writing those down, would you have given Mr. McClinton an opportunity to review them?
Yes.
Why is it you do that?
To verify accuracy, and if there's anything that is inaccurate or anything that would need to be modified, the defendant has the opportunity to advise me of the corrections that would need to be made, and we can make them accordingly together.
And those two things I handed you as people's proposed exhibits 1 and 2, did they fairly and accurately depict for exhibit 1, the advice of rights form that you read to Mr. McClinton and he signed?
Yes.
And is the second one the question and answer sort of narrative format that you just referenced that you gave Mr. McClinton the opportunity to review and then he in fact signed?
Yes.
And are they dated and timed?
They are.
And what is the date and time on these?
April 17, 2023, 8:51 a.m.
Your Honor, at this time, people would move to admit people's proposed exhibits 1 and 2. Thank you. And move to publish the report. You can hand it. Since I know the court reviewed it, I won't play the video version of it. And just one more question, I suppose, Mr. or Detective Faircat, I sort of covered it, but do you see the individual that you interrogated back on April 17th here in court today?
I do.
Could you point to him and identify him for narcotical clothing?
Wearing a green Wayne County jumpsuit with chain seals.
Your Honor, I ask that the record reflect the witness's identification of Mr. Clinton. And no further questions from the people, Your Honor.
Yeah, let me ask you a question. All right, officer, when you spoke to my client, there was some discussion about whether or not he fired. Is that correct?
Correct.
All right, and you say that he fired into the ground?
I believe that was said during the interrogation.
Okay, he shot into the ground. Right.
I believe that's what he said.
And then he just picked the gun up from the grass after he got jumped.
That's what he advised.
That was not his gun.
That's what he stated.
And let me ask you this, were you out there that night?
I was.
April 15th?
Yes, sir.
All right, and you compiled all the police reports and sorted them all, put them all together for a package, submit to the Wayne County Prosecutor's Office?
The system does that for me. When they complete a report and supplements, they all go under the one report and extra. I don't have to apply.
And there was a second individual arrested that night, Mario Boston.
Correct.
And he was alleged to have shot a weapon and gun was recovered from him.
Correct.
And is this all within 1 minute?
I'm sorry, can I strike that?
Right.
The weapon was not recovered from him. The weapon was recovered from the alleged to have shot down that night. Correct.
Right, and then, okay, and and that was within 1 minute of this alleged first shooting or second shooting, I don't know which came first. But it was all at the same time.
It was around the same time, close proximity in time, correct?
All right. And the vicinity was all the same, within a block?
It was within a block or two, roughly.
Okay. And it's found in this report, the second person's name?
Yes, sir.
That individual did a statement?
That's for a different case, not this one, sir.
Okay. And how did you make that conclusion?
Which conclusion?
That these shootings were separate?
Based on video.
And did you watch the video that shows how the melee started?
Yes, sir.
And would you describe the video to the judge? And we're gonna ask that.
Sure. Video shows two groups of individuals that are passing each other, which spills out into the street, spills onto the grassy median area. Fight entails multiple individuals fighting, which results in observing the defendant, Mr. McClinton, with a handgun and shooting. And then once the shot occurs, everybody starts to flee in random directions as if something chaotic had just happened.
All right, and you can actually see my client?
Yes.
All right. All right, and at this time, Your Honor, I'll just ask that prosecutor play that video.
I'll stipulate for submission.
Okay.
Make it.
So it'll be people's exhibit or?
Defense.
Okay.
And you'll be able to watch it, right, yeah?
Yes, I'm in the court Zoom room. I can share my screen.
Yeah.
Oh, okay, outstanding.
So your exhibit A hasn't been admitted. Correct.
Yeah, let me, thank you, Your Honor. Let me approach the witness.
Sure.
This is a map of downtown. Listen, you can just put your initial where the two shootings were. This is not this one. Mark.
So on the defense exhibit A, the star that you've drawn, that would have been around the area that the fight had occurred and where it's.
Was my client?
Yes, sir.
Okay, and where's the second?
The second one would have been further down, closer to base.
Is that where the fight was or where the gun was recovered?
I'm sorry, what gun?
The 9mm. There's a second gun, you said, right?
Correct.
Right. Is it found in that location that you're speaking of now?
It's found in an alley, correct?
All right, just put a little mark there.
And just to be clear, this is not your client's gun.
It's
correct?
not my gun.
Second one.
Right. Because we haven't determined what my client's gun was. Both marked, eh?
Yes, sir.
Now I just have, I move to have this fit into the. Oh, this is, yeah, what's your?
Detective Becker.
This is, Detective Barcat's indication of where the two shootings were found that night.
No,
Matt,
objection.
Detroit.
Oh,
Downtown.
so this will be admitted as exhibit, A.
Thank you. So, you got your report with you? Just so the judge is clear on the time. This is just a 1 minute separation in time. You have your police report.
I can grab my file. I can grab my file. Thank you. Sorry about that. I have my reports and I have the generated reports by the officers as well.
But you were just looking for the times.
Okay.
Of the alleged two shootings. Can you share that report? When the radio runs were announced, shootings.
Not sure what that is. Have a seat.
So the one where it's alleging your client, the officers indicated was on 11:31 p.m. And the other one where the officers started hearing gunshots for the separate case would have been around 11:30.
All right. Thank you. No further questions with the chair.
Can you read the record?
Executive, I suppose we're asking questions about, we're doing video in this case. Correct. And did you include video in this case?
I did.
And
Yeah, the first, whatever.
And did that video fairly accurately depict the scene that night?
It did.
You sure? All right. And you recovered it? Part of your investigation?
It was turned over to me. I requested it. If it's green light, which that appears to be green light, that was requested through our audio video team paper. There's also rock video that was admitted as well as officer body cameras.
Your Honor, this time I'm going to publish what's been, I suppose, admitted as people or defense exhibit B. I think it's right now.
Yes.
It wasn't admitted
We stipulated.
to A and B. Okay,
Correct.
I didn't know that. Okay. So it's been admitted.
Right, so then, permission to publish to the court then? And just for the record, the parties have stipulated to what is the Randolph Cadillac and surface lot camera 4.
Yeah, it's showing the video camera of something happening in a street
All
on
right, hold on.
415.
And just for the record, I'm stopping it at 10:31 p.m. No further questions, Your Honor, for this witness.
And, now, when you saw this video, how did you make out who was who?
I wasn't basing my investigation based off this particular frame of video. There was this combination of the three other frames that are in this video, as well as Rock Financial and Body Cam video.
Okay. But, if I were to describe this scene, I can't tell where my client was. Can you tell where he was on the screen from this video?
From the lone video in itself, I can because I've reviewed several other frames and I know where he is.
Okay, I got that. So is he by himself or is he being attacked by about 25 people?
He was not being attacked.
Was he on the far right side of this frame?
When the video started, correct. And then it spills into the across the street where the grassy median is in front of that red sedan.
All right, so at the beginning of this clip, you saw maybe 15 people walking toward him. Is that correct?
There was a group of people that were walking in both directions.
All right, well, Judge, you have to.
Yeah.
You can make your own.
Yeah. No further questions from the people, Your Honor. And at this time, the people are calling for Samuel Jones.
Mr. Jones. Jones?
Make sure you speak up in that microphone.
Thank you, Your Honor. Good morning, sir. If you please introduce yourself to the judge.
Oh, Bill. You can put it in your lap.
Samuel Jones.
And Mr. Jones, I want to take you back to April 15th this year. Were you at some point in downtown Detroit?
Yes.
And at some point, were you near the 7-Eleven at the intersection of Cadillac and Randall?
Yeah,
And sir, did something happen there that brings you here today?
yeah,
What was that?
the incident broke out.
And when you say incident, can you sort of describe for us what you mean by that? A little scuffle?
Yeah.
And how many people would you say were involved in the scuffle?
Mr. Jones, let me just speak up.
Probably 40,
And what did you do when the scuffle broke out? And you just testified that at some point you got shot?
Yeah.
And tell us about that.
I don't even know what happened.
Do you remember how many shots you heard? Sorry?
One.
There's one? And you say it was just one shot because you heard it, you felt it, you saw it. What are we talking here?
Both.
Both.
I can't hear you, Mr. Jones.
I heard it and felt it.
And where were you shot?
Real.
In the ribs? And did you see anyone with the gun?
No, I didn't see nobody.
And do you remember where you were in that area when you got shot?
In the middle of the street.
And what happened after you got shot?
I heard it running away. I heard it.
And then what happened?
Yeah.
And at some point, did you get medical attention?
Yeah, I got mad.
Did the ambulance come? Did you go to the hospital on your own? Where we talk?
I'll leave.
Did you have any sort of weapon on you that night? Sir, I'm going to show you on the TV over there what's previously been admitted as Defense Exhibit B. Sir, this is what's been previously admitted as Defense Exhibit B. Do you sort of recognize this area?
Yeah,
What do you recognize it as, sir?
I think that's where it happened. That's 7-Eleven.
And you testified about sort of running in the grass. Do you see that grass in this exhibit or no? When you got shot and went running, do you remember which way you went? So I'm just gonna play about the first minute and a half of this for you. I want you to point out if you ever see yourself in it, all right, or if you can recognize it and recognize where you were at. for the record, I'm stopping that at 10 minutes, 30, or 10, excuse me, 10 o'clock, 10:30 p.m., 10:31 p.m.
You said you wanted me to identify myself.
Yeah, Mr. Jones, did you see yourself in there at some point? And could you just sort of describe for the court where you were in relation to all these cars that we're looking at here? Yeah, you were now, but at some point, sort of, could you just describe if you were near anything in this image?
Like direct.
In the sort of grassy median between the two sets of lanes? In the red right there, sir? And so this is at 10:29 and 46 seconds. Stopping it at 10:30, 29 seconds. That was you in the red t-shirt, sir? And you testified that you were involved in the scuffle before you got shot. Do you recall sort of where you were when you got shot? Were you still on the street? Were you on the median there? Where were we talking? In the street. Okay. No further questions, Your Honor.
And so right as it got to about 10:29, 10:30, you left the safety of the sidewalk and went and joined the fray. Is that correct?
Correct.
All right, no further questions.
Can you read it right?
No, Your Honor. No further witnesses, Your Honor. No.
Yeah, Your Honor, we just have, we don't have any witnesses, but we do want to speak to Officer Martin.
If he were here, he would testify that he observed Mr. McClinton firing to the ground. That was mentioned in this police report.
That's a
Okay.
thank you. No.
And, Your Honor, this time, the motions from the people to bind over. People were bind over on all counts as charged. The court certainly heard the testimony. It's certainly circumstantial as it relates to Mr. Clinton's identification. The court has the benefit of his interrogation afterwards, where he even admits to firing a shot. You know, he claims he was firing it so people would get away from me. That was on page 2 there. He himself said he shot towards the ground, but we certainly heard from Mr. Jones here today, who doesn't know Mr. McClinton, couldn't identify him, but was in that exact same area. And certainly we did hear about a shooting in a different area, about 1 or 2 blocks away. It happened about a minute or 2 later. There's some specific timing from Officer Martin that I think is really important here. And that is this, that Officer Martin said, yeah, I was arresting Aaron McClinton at the time I heard the gunshots at that other scene there, which we have the benefit of the video here that was admitted as Defense Exhibit B. It's got times on it that sort of show Mr. McClinton and Mr. Jones. They're right there in that same median strip area near that red car in the exhibit. Mr. Jones said, yeah, that's where I was involved in it. And that's where I got shot at. As for the intent to murder, I'll just say this, that this is sort of what I'll tell the jury across the street. How many gunshots does it take to kill someone? And I suggest in this case, it would only take one. Certainly, it doesn't matter that he didn't die, but he could have, and I think Mr. McClinton's intent is evidenced by his use of the firearm here, even if by his own account, he sort of mitigates it in his statement. If the court doesn't believe that there was sort of the intent necessary for intent to murder or an assault with intent to be grave bodily harm less than murder, I'd ask that the court consider the alternative count of reckless discharge causing injury, the 2-year misdemeanor. As for the CCW count, I suppose the best evidence for that is Mr. McClinton's own statement, which was admitted as Exhibit 2, and the question from Detective Bearcat. Question on page 3: did you hide it in your clothing? Answer: yes. That's only because I was running. I feel like I had it and they were going to shoot at me. Question: where was it tucked in your clothes? In my waistband. But he certainly, by his own account, admits to concealing a firearm on his person. We certainly heard the testimony of Officer Martin, who chased him for about 60 seconds. Not a short period of time, really. Yelling at him to stop, saying saw him fire the weapon, saw the muzzle flash that night, told him to stop, and took off running. So I do believe that the resisting and obstructing count is also warranted. And as I indicated earlier, the court doesn't believe that there's the assault with intent to murder because of the intent requirements. I'd ask that the court consider the alternative charge of reckless discharge of firearm causing injury. Thank you, Ryan.
Thank you. I think everything starts with the mens rea of my client. What was his mindset at the time? We know this is a proper cause here, and we know it's what crime was committed, who committed it, but also this is an opportunity for you to look at the credibility of the witnesses and quality of the exhibits that were admitted. So I rely upon the defense's exhibit B, which would have been the video of clearly 40, 50 people running in chaos, fighting. My client is never really described on the screen where he was in the screen, but we do know that the victim was in red. He was in a place of safety, and he decided to join a melee, and he alleges that he got shot. Now, my client has made a statement that he found the gun on the grass, in the grass where the video shows, is on the far side of the video, and he picks up the gun, and at some point, the idea of self-defense has to come to everybody's mind, just to be fair. There's 40 people jumping on you. You don't see a party assisting my client. He's there on the ground, and you don't know what the fight was about. The victim doesn't know what the fight's about. It happened within less than 1 minute. Now, had this been a police officer being attacked by 40 people, we would expect a police officer to draw his weapon and fire. Any person, 50-year-old woman, getting attacked by 40 people, you would expect her, if she had the opportunity to draw a weapon from somewhere, because there's no testimony that my client carried a weapon prior to that shooting. Now, this is a situation, as the brother prosecutor here has stated. At most, this is a negligent discharge of firearm. There's no intent to murder, wound, or anything to anyone. It's just to preserve his own life and his own self from danger. 40 people kicking and stomping on you to take your life. Sometimes we even have a lucky punch that would drop somebody and take their life if they fall off a porch, hit their head on concrete. Clearly, you have 40 people fighting out here. From the victim himself. My client's statement, once you read it, Your Honor, is that he shot into the ground, and if it's grass, there's no chance of a ricochet. We stipulated to the Officer Martin's testimony that he saw my client shoot into the ground. So now, we don't have just a civilian, but we have a professional, trained observer who made that call that the bullet went into the ground. Now, funny thing is, with this particular case, we can't say that anything associated with my client had anything to do with this individual, because there was a second shooting at the same time. This is not made clear by the people, but it's, if you look at the map and you notice where everybody's running, it's within this small area of downtown. So if we know that somebody can run a mile in 5 minutes, you can run a block in less than a minute. And this gun was recovered by Mario, not recovered, but it was found on Mario Boston. And we don't understand why this is in this report of this case, except for obviously it was associated with this case. And you heard nothing about gunshot residue. You have no ballistic evidence about the victim shooting and alleged firing from my guy gun that was found on the grass. So there's a whole lot of mystery here. But we believe that at most a negligent discharge, he has idea as self-defense, but in no way that is there any mens rea supporting an intent to do great bodily harm, less than murder, or assault with intent to murder anyone. It happened too fast. There was no opportunity to develop such an intent. These people are total strangers. There's no vendettas. There's no prior recognition of each other. The victim doesn't even recognize this individual. So this was just some mayhem, and it wasn't on the part of my client. It was these 40 people attacking him. And that's all I can say at this point, Your Honor. We ask that you not bind him over on any of the felonies. He was just running with the weapon that he recovered, and he didn't want to get shot. How often do you see in the news today that a baby would have a toy and get shot by the police? He understands that concept. He didn't want to pull the weapon out, and they have the fear that he's going to turn and shoot them. So he just tried to get to a safe location. And there's not even any testimony that my client even heard him chasing him, that sort of thing. There's just too much chaotic things going on at that one thing to try to put this all on my client. Like he had all the faculties and wits about him and maturity to say, oh, I need to do this at this exact moment, and this at this exact moment. This was a riot downtown. And the police told you there were multiple shootings down there, and you don't know where this bullet came from. And we just ask that you not bind them over on the AWIM, great bodily harm, resisting and obstructing. At most, that's a misdemeanor. So, and it's the CCW, I don't even think he had that before he started running, trying to get rid of it. So, yeah, we just ask that you do what's just in this particular situation. And we thank the police officers for not shooting, by the way. Thank you.
Very, very briefly, Your Honor. So self-defense, almost always going to be a question of fact, trier of fact. That's people be Walton, WALTONEN, 272, Michigan Ave 678, 2006. Quote, affirmative defenses in criminal trials should typically be presented and considered at trial, and that a preliminary examination is not a trial. But sort of the best evidence that Mr. McClinton knew he had done his own statement in the statement that was submitted as People's Exhibit 2. On page 3, question, why were the police chasing you? Answer, because I just fired the gun. Question, did you know they were police officers? Answer, yeah. Question, did they tell you to stop? Answer, yeah. Question, did you stop? Answer, no. So for that reason, we ask that the court find this over, or if the court doesn't believe this intent sufficient for the AWIM and GBH, the court consider a reckless discharge causing injury, which is 752.861. Thank you, Your Honor.
Thank you for your testimony from 3 witnesses, and I will not go through all the facts, as you all heard them. I do think this would be a question of fact for the trier of fact. For count 1, self-intent murder, there's testimony that the defendant was at the scene and has had a gun, as observed by Officer Martin, as well as through the defendant's own statement. Officer Martin saw the defendant with the gun and the muzzle from the gun being fired. Officer Martin also stated that he heard gunshots after the defendant was arrested. Officer Rajani, I believe that's his name. I'm sorry, Vericut. Officer Vericut stated that the defendant was in the video that was viewed as Exhibit B based off of other videos that he saw during his investigation. Officer Martin, through stipulation from his report, stated that the gun was pointed or shot downward. The video also shows that, the fight looked like they were on the ground scuffling. The gun was pointed, someone was shot with a deadly weapon in close range, and that's why I say this is going to be a question of fact for the trial fact to determine the intent, which will also cover count 2, which is assault with intent to great bodily harm, less than murder, count 4 as well. Count 3 through the defendant's statement, he stated that he had no CPL. Count 5 has been established through Officer Martin's testimony, which he gave several commands to the defendant to stop after seeing the defendant fire a gun. He gave chase for 60 seconds before the defendant finally fell, was arrested. And then counts 6, 7, and 8 are attached to assault, intent to murder, great bodily harm, plus assault. And count 9, felony firearm is attached to resisting. So, Mr. McClendon, I will have you bound over to Third Circuit. You are in custody, so it'll be 1 week from today. It'll be May 15th at 9:00 a.m. Anything else, Mr. Barty?
Thank you. No, Your Honor, thank you.
Have a blessed one, Your Honor.
No,
Oh, okay.
Yeah.
See, I just put your client in. I switched up the name.
No.
Mr. Yami? Okay, we're on the record that the people of the state of Michigan versus Mohammed Yusuf Ajami, case 2255746. Mr. Ajami is charged with count 1. Gambling activities, felony violations, count 2, gambling activities, 5 felony violations, count 3, gambling activities, felony violations, set for a probable cause conference appearances.
Morning, Your Honor, Robert Hayes, Assistant Attorney General here, at People, P69006. And good morning, Your Honor, Austin Benz, I'm P7448 on behalf of the General President of the Zoom.
Mr. Ajami, can you state your full name for the record, please?
Good morning, Your Honor. It's Mohammed Yusuf Ajami.
Say that one more time, you're muted. Go ahead.
Mohammed Yusuf Ajami.
Thank you, good morning.
Mr. Hayes and I have been on constant contact trying to get this resolved. I think we need a week.
All right, Mr. Bazzi, forwarded a deviation letter to our office. I sent that up the chain, so we have a response. Obviously, if the deviation is approved, that would resolve the matter. If not, then we'll figure something else out.
May 31st, Wednesday.
Okay. Yes. I might be gone. Okay. Thank you.
You're welcome. So you want to do 9 o'clock or 8:30?
8:30.
Let's do 8:30.
Good.
Okay.
Thank you, Honor. Thank you, Honor. Have a good day.
Mr. Ajami,
Thank you, Your Honor.
To May 31st at 8:30, you can still log on Zoom. You do not have to be in person.
May 30th.
You're all set.
I'll see you
Oh, no, this is not a prosecutor. Yes.
Yes, Your Honor.
Right here. All right. This is the people of the state of Michigan versus Tiffany K. Villanueva, 2356469. Ms. Villanueva is charged with count one, attempted assault with a dangerous weapon, one is assault, as well as count two. Set for exam today. Appearances.
Alexander Kirker on behalf of the people, P 86282.
Good morning, Your Honor. Stephanie Person on behalf of Ms. Villanueva, P 57096.
Ms. Villanueva, can you state your full name for the record, please?
Stephanie K. Villanueva.
Thank you. Good morning.
Welcome. Good morning.
Okay, I have a waiver form for me. Is it correct, your client, certain person wants to waive her?
Yes, Your Honor.
Okay, Ms. Villanueva. Questions? If you can't hear me, or if you don't understand, let me know, okay? Is it your wish to waive your preliminary exam?
Yes.
Okay. Do you understand that you have a statutory right to a preliminary exam?
Yes, I do, Your Honor.
And that if you were to demand that exam today, the people would have to show at the probable cause standard, which is a much lower standard than criminal law, but still a standard, that those two charges I read off were committed in the city of Detroit and that you probably committed those crimes. You understand that? And that by waiving your exam today, that means that people do not have to prove anything today.
Yes, sir.
And you also understand you are not giving up your right to trial.
Yes, sir.
Okay, did anyone force you or threaten you to waive your exam?
No, Your Honor.
Did anyone promise you anything?
No.
Any objection from the people who waiver?
No objection, Your Honor.
I find your waiver to be freely, understandingly, and voluntarily given.
Yeah.
I will have you bound over to Third Circuit Court, Frank Murphy Hall of Justice, for a ring on the information 2 weeks from today, since you are out of custody, so that'll be May 22nd at 9:00 a.m. Okay? Anything else from either party?
No, Your Honor.
Okay, we are off the record.
Your Honor, may I have approach on a totally unrelated?
Sure. Okay, 2356368, people of the state of Michigan versus Clifton Terrell Shorty. Mr. Shorty is charged with count one, police officer assaulting, resisting, and obstructing. Count two, misdemeanor, disturbing the peace. With official offender, fourth offense, I was separate that. Harrison.
Anyone to walk to P54828 on behalf of the people?
Vanessa Hamilton, K2107, on behalf of Mr. Shorty, stands to my right, which is Aaron.
Shorty. Then we're ready to proceed.
People are ready to proceed, Your Honor.
If there's anyone on YouTube or Zoom who may be watching or maybe a potential witness, now is your time to log off. And there's no one else to report from the necessary parties, I believe officer in charge.
This man,
Okay, any objections, the officer in charge being the purpose of the defense?
No.
Okay. Everybody.
Thank you, Your Honor. People call Officer Kaylin Johnson.
Yeah.
Johnson.
That's what we're
Yes.
Go over to the front here, make sure you speak up to that. Put your lap.
Officer, can you state your name and occupation, please?
Kaylin Johnson. Police officer.
And who are you an officer with?
On the 11th precinct,
And what city is that?
Detroit.
How long have you been?
3-4 months, going on 4 months.
Were you on duty April 9th, 2023?
Yes, I was.
Were you on duty in the area of 19187 Cherry? Cherry.
Chairs. Yes, I was.
And I believe that's spelled CHARES.
Correct.
And what type of uniform were you in?
Full uniform,
And type of vehicle you were in?
fully marked vehicle.
When you arrived at the scene, what did you observe?
When I arrived at the scene of 19187 Cherry Street, I observed a silver Equinox sitting to the left curve, appeared to be 6 inches off the curve, and it was occupant in it. So I made a U-turn and got out the car and went to talk to the occupant in the car. My partner talked to his ex-girlfriend that was on the porch.
Okay, so you were responding to a radio call in?
Yes, of a disturbance.
Okay, the person in the vehicle, is he present, is that person present in this report?
Yes, he is.
Could you point him out and show our piece of clothing that he may be wearing?
Yes, he's right there.
And let the record reflect that officer has identified the defendant. Are you pointing to where he's sitting?
Black shirt.
Thank you, Your Honor. Did you have a discussion on this gentleman?
I attempted to have a discussion with him. He kept rolling his window up on me numerous of times.
I'm sorry, could you say that again, a little slow?
Yeah, when I first arrived on scene, I attempted to have a discussion with him, but he rolled his window up on me numerous of times.
How many times did he roll up the window?
3.
What else? What happened next?
I went back to check on my partner because I observed numerous people kept coming outside the house, and then I observed people being around a vehicle that was in the driveway of this location.
And after the third time you spoke to the defendant, were you ever able to speak to him?
After the third time, he did start talking to me, and then he stopped talking to me. He said he didn't want to talk no more.
And what happened at this point?
I called for more units because of the crowd that was on the porch, and I didn't know where people was coming from, but the crowd was getting bigger, so I called for more units to come and assist.
And did a high ranking officer eventually show up?
Yes, it did.
And who would that be?
Sergeant McClendon.
What did you observe next?
What, at the point where Sergeant McClendon came?
Yes.
So Sergeant McClendon came, made the location, asked Mr. Shorty to step out the vehicle. Mr. Shorty said no. Sergeant McClendon placed a cuff on him, and Mr. Shorty stood up and said, "You done effed up." Pushed him, and then officers tried to detain him at this point.
Did they eventually detain him?
Yes, after getting him to the ground, a taser was deployed, took it back, and we was able to get him placed in handcuffs.
I have nothing further for this witness, Your Honor.
You said that you were in the area for a disturbance?
Yes, correct.
Okay, and when you got there, you said that you noted a vehicle that was parked off the curb.
Yes.
Did you see the disturbance that you originally called?
When I really got a call for there, no, I didn't see the disturbance.
And so then when you were speaking to Mr. Shorty, or when you were able to speak to Mr. Shorty, if you were you able to tell him, were you able to ask him any questions about, did you ask him any questions?
I tried to ask him questions, kept rolling up the window, and I asked him numerous times, "Can you just leave the speedster?"
Okay, so you said did you ask him to leave?
Yes, numerous times.
Okay, and why were you asking him to leave?
Because he was just parked out in front of the ex-girlfriend's house.
And so at any point did you, when he did eventually was brought out of the car, did you at any point have any physical contact with him, or were you?
I did have physical contact.
Okay. In what way?
When you ask for physical contact, what do you mean by that?
Did you help in bringing him to the ground?
Oh, yes, I was holding on to his right arm at the time when he was striking officers.
Okay. And at any point, were you, so at any point, were you going to arrest Mr. Shorty?
I just wanted him to leave.
Okay, was he under arrest at any point?
At the time, no, he wasn't.
Okay, but then, once he was tased, he wasn't arrested?
Yes.
Okay. And when you spoke with him, did you open the door at all when you were speaking with him?
No.
Okay. Did someone open the door, or did he open the door? Yeah. If you know.
I'll look. That I don't know.
Okay. But at some point, the door was opened and
yes,
he was brought out. No further questions.
Yes, Your Honor. When you were talking to the defendant, he was not under arrest, correct?
Correct.
And yet, Sergeant McClendon was the one who decided to put him under arrest.
Yes.
No confirm. That's Sergeant Darrell Quinn.
Sergeant McClendon?
Speak up in the microphone.
Yes, ma'am.
Are you ready, Mr. Sabah? Yes, you.
Yep.
It's all skinny, sorry.
Since I was king.
Yes, sir.
Yes, sir.
Did you state your name for the record?
Darrell McClendon,
And how long have you been with the Detroit Police Department?
45, going on 46 years.
And when you were on duty, April 9th of this year,
Yes, sir.
and were you on duty in the area of 19187? Pronounce it again, I'm afraid.
Cheers.
Thank you.
Yes.
And when you were, what uniform were you wearing?
I was wearing my Class B uniform, which I'm wearing right now.
And type of vehicle you were in?
A marked police vehicle.
And what did you observe when you arrived at the location?
When I arrived at the location, I observed a lot of officers surrounding the car, trying to convince the passenger, the driver to get out of the car. And
What type of vehicle that was that?
I don't remember what kind of vehicle. It was a regular vehicle.
Is the driver of that vehicle in the courtroom today?
Yes, sir. Mr. Short is sitting right there.
Would you describe the piece of clothing that he's wearing?
He would be wearing black slacks and a t-shirt or just black shirt. Gym shoes.
Record should reflect that the sergeant has identified the defendant.
So request.
What did you do upon arrival?
First, I talked to the complainant to see what was going on, and I had found out or discovered that Mr. Shorty had followed her from the west side and had assaulted her on the west side, and he was currently in front of the house.
What did you do with that?
So I'm sorry, what I did is I went up to Mr. Shorty's vehicle, and the officer was trying to convince him to get out of the car or leave, and he refused. So I told Mr. Shorty, I said, Mr. Shorty, please get out of the vehicle. And
did he obey?
No, he did not.
What did you do next?
So I reached in his car to open the door because he was under arrest, let him know he was under arrest. Reached in the vehicle and with my handcuffs in the hand, I was handcuffed with one hand. And he resisted at that time.
How did he resist?
Pulling away. He stood up, we got him out of the car, he stood up and he was resisting, trying to pull away from me. And the officers they thought he was gonna hit me.
And what happened next?
All the officers on scene rushed him and we took him to the ground. He was still fighting. So we had one officer tased him, and that way we were able to handcuff him.
And nothing further.
I might need to show a video, Your Honor, so I'll comment on here. Or it's hard to. So you stated that when you arrived on scene, what was the first thing you did? Did you speak to the complainant or did you go to the car?
Yeah, I spoke to the complainant
Okay.
to see what was going on, and then I asked the officer what happened.
Okay, who was the complainant in this matter? Who was the complainant?
I can't remember the name.
Okay. Were there multiple people at the scene?
Yeah, it was, her whole family was out on the porch.
Okay, and so speaking with the complainant,
I beg your pardon?
how long were you speaking with the complainant?
How long did I speak to the complainant?
Yeah, prior to approaching this.
Just a few seconds. Just to find out what was going on.
And so did you ask anyone else on the scene what was going on, or you just spoke to them?
No, I talked to my officers. I always approach them to find out what's going on, why I'm at the scene.
And why were you at the scene? Were you called?
I believe I was called, but what happens is that when I hear a disturbance going on, I automatically go to it. And when I have multiple cars or they call backup, I go in case there's use of force that I have to handle.
Okay, and that may be because you're a sergeant?
Yes, I'm the supervisor.
So when you got to the car, what was your understanding about why he was being asked to get out of the car? Or was he being asked to get out of the car? Or was he being asked?
Yeah, they asked him several times, either to leave or get out of the car.
Okay, and why were they asking him to either leave or get out?
Because the complainant was afraid he was gonna assault her again, that he, I believe he had been drinking, but I did not do a test on him to verify it. And she was just afraid of him.
Okay, so so when you arrived there, were they still just asking him to drive away, or were they asking both at the same time?
No, they was asking him to drive away or get out of the vehicle. The complainant was at her parents' house, or mother's house or something like that.
Okay. And so then when you started speaking with the person in the car, with my client, did you ask him to drive away, or did you ask him to get out of the car?
No, I told him to get out of the car.
You asked him to get out of the car. Why did you ask him to get out of the car?
To put in the words of my lieutenant, we're not to shoot police, we're gonna shoot people away. If you violate a state law or city ordinance, we lock you up.
Okay. And what law or ordinance was violating?
He's violating the domestic violence act.
And besides speaking to the person that you believe to be the complainant on the scene, did you speak with anyone else on the scene?
Well, everybody was talking at one time.
Okay. So did you do any investigation into the domestic violence?
At that time, no, I did not, because I trust the judgment of my officers.
Okay. Did you have a body worn camera on that day?
Yes, I did.
Okay. Was it on operation?
Yes, it was.
If I showed you, would you be able to confirm that that was probably what was going on that day? But that's your camera showing that.
Yeah, my camera should show that.
So that's for you. Does this look like what was going on that day?
Well, that looks like me.
So this would be.
Yes.
You behaved. Max. Mark, you can have this as that's exhibit 1.
Tape or.
For the record, I'm just gonna play the first part of it.
Are you moving to admit or marking it?
I would move to. No objection.
Okay, so leave it in today.
Thank you. So this is. So I'm pausing and for the records, the 12-second mark. And so this is when you initially walked up to the car and were speaking with him?
Yes, sir.
Okay, and on the other side of the car, is it that another officer opening the door?
Yes, it was.
The passenger, okay. And so did you know that they were already opening the car when you came over there?
At the time, they were attempting to open the car. He had his windows rolled up. He kept rolling windows up and down. And when he finally rolled it down to talk to me, and he was telling the other officers to get away, I reached in and opened the door.
Okay, so you opened that door. Okay, so at what point did you let him know he was under arrest with that?
Yes.
And did you read him his Miranda rights or anything?
I did not.
Oh. Do you know if any other officer notified him that he was under arrest besides you?
I couldn't testify to what they told me.
Okay. And do you know, no further question.
Redirect? No redirect, Your Honor.
Yeah, the skinny Mike. Skinny like I used to be.
Any other witnesses?
No other witnesses, Your Honor.
Nothing for the defense.
Your Honor, the people motion that defendant be bound over to circuit court on count one, police officer assaulting, resisting, obstructing. I will note that count two is still resisting. And we reserve our.
Right, Your Honor. And obviously object to the bind over, specifically because I don't feel that the elements of defense have been made, and I think that's for a number of constitutional violations that occurred during the stop. In terms of the charges, to resist a police officer, there needs to be a lawful command. I think from the testimony today, it's unclear what the officers were trying to tell Mr. Shorty to do, whether they were trying to tell him to go away, whether they were telling him to get out of the car, whether they were opening the car. The sergeant testified that yes, another officer was opening the door and that he reached in to open the door. It's unclear that the testimony about if he was ever, he was told he was under arrest at some point. But he also was not told, he was not ready for Miranda rights. He was not told that he was under arrest until possibly the police had already opened the doors and you guys pulled him out. It's unclear if he was in a custodial situation or what was going on. And for those reasons, I think that there was no lawful command. It was unclear what was happening. It's unclear if they should have been doing that, especially to my client who's sitting in a car. Some of the police officers are holding open the door, pulling him out of the car. First, they were asking him to drive away. I think it's a little unclear. I don't think that they meant their verdict.
Your Honor. Defendant wasn't cooperating with the police from the get-go, without raising and lowering windows. And so when a sergeant came along, he went over after doing a preliminary investigation, he went over, told and he did testify and believe that he told the defendant he was under arrest, pulled him out. They had attempted or to handcuff him, and he resisted, as the sergeant testified. And as far as the Miranda rights are not needed to be read unless they were to question him, and there was no questions asked. People have met the proof, standard probable cause in this matter. And what was going, whether he was or was not under arrest at the time, is still a question of fact, even though it's our standpoint that he was under arrest. That should have been notified by the fact of one of the handcuffs, but he was told by the sergeant that he was under arrest. So he asked that the defendant be accountable. So we just. So,
Ooh, same testimony, a little all over the place, or confusing in the beginning. Through cross, and a little more clarity from Officer Clinton or Sergeant Clinton. I do think that people have been very low burden of proof. People have to show the probable cause standard first that the defendant assaulted, battered, wounded, resisted, obstructed, opposed, or endangered police officer who was state authorized performing his duties. I think that happened in this case after determining that Officer McClendon and the officers were trying to speak to the defendant about a domestic violence violation. Second, the people have to show that the defendant knew or had reason to know that the officers in this case were police officers, and that stated Officer McClendon's testimony in the full uniform, and the video did show that as well. Third, that the officers gave the defendant a lawful command, who was making a lawful arrest, and was otherwise performing a lawful act. I think that would be the question of fact, for the trier of fact. This level, I do believe, based off of Sergeant Clinton's testimony, that he was making a lawful arrest or attempting to, based off the domestic violence information that he received. Fourth, the defendant's actions were intended by the defendant. That is not accidental. I do not think that the defendant's actions were accidental in this case. So with that, Mr. Shorty, I will have you bound over to third circuit. You are not in custody, so it'll be 2 weeks from today, May 22nd, 9:00 a.m. Framework of justice for your rank on. Okay. Anything else from either party?
No, that's it.
No, Your Honor.
All right, we're off the record. On Mr. Shorty. Okay. You're on the record, this is people of the state of Michigan versus Roosevelt Theodore Evans, 21058811001. Set for a motion here today. Appearances.
Alexander Kirker on behalf of the people, P86282.
Richard Zalak on behalf of defendant Roosevelt Evans, P77193.
Mr. Evans, you are muted. If you could have that device unmuted, then state your name.
Roosevelt, I believe you need to ask someone to unmute your device unless you have the ability to do it there. You're still muted.
Mr. Evans, once we get you unmuted, I'll have you put your name on the record. Can you give us a thumbs up to let me know that you can hear us? Okay, as long as you can hear us for now, we're okay. We don't need you to speak quite yet.
You still need to get someone to unmute you, Roosevelt.
Okay, there we go. Okay, we got it, Mr. Roosevelt. Evans. What's your name?
Roosevelt Theodore Evans Jr., Your Honor.
Thank you. Good morning, sir. Okay, Attorney Salaka, thank you for your patience. Go right ahead, this is your motion.
Yes, Your Honor. Today we're here on a motion to dismiss this case for a violation of my client's rights to a speedy trial and his due process. As outlined in the motion, there is a presumption of prejudice that occurs after 18 months of the prosecution's failure to bring the case. In this instance, my client was not arraigned until 21 months after the original warrant was issued on 6/14/21. And the prosecution has failed to present any evidence in written form to demonstrate that my client would not be prejudiced by bringing this case at this late time now. Also, in the event that the court does not grant this motion, we would request an evidentiary hearing on the facts of how this case came to be, because we do want stated for the record the following, if I may, Your Honor. Mr. Evans was arrested on 6/14/21 in this instant case. He was released on bond, and then he was arrested on 7/28/21 in Macomb County on a separate matter, at which time his PSI revealed the pending warrant in Wayne County. He then began to serve his prison sentence at MDOC on 12/21/21, at which point, pursuant to MDOC policy, a lien check was performed and revealed that there was no current felony warrants out in the system for him. On 1/5/2022, another lien check per MDOC policy was performed, which revealed that there was no felony warrant in the database, and it was either dismissed or revoked. On 11/7, following a positive parole review per MDOC policy, again, another lien check was performed, indicating that no pending felony warrant or detainer was in the system for Mr. Evans. Then 24 hours before Mr. Evans was scheduled to be released, it indicated a lien check was performed, again, pursuant to MDOC policy, which now indicated, again, 21 months at this time after the original felony warrant was issued, that there was now a felony warrant in the system. And the evidence in this case suggests that in the interim, upon MDOC's notice to or contact with the Wayne County Prosecutor's Office, that warrant was likely dismissed upon request for final disposition. And at a later date, just before his release, they attempted to reissue the warrant for his arrest and arraign him before you today in an attempt to subvert my client's constitutional rights. So if this motion is not granted, we would respectfully request an evidentiary hearing on this matter to determine exactly how this proceeded.
Okay, Mr. Kirker.
Your Honor, it is our understanding that after the defendant was arrested on these charges, he was incarcerated starting October 27th, 2021. Our office received notice from the MDOC on February 6th, 2023. 36 days later, he was then arraigned on these charges. We do not believe that there has been any violation of the defendant's constitutional rights. We have not heard the defendant asserts this right to a speedy trial until the day before the preliminary exam. We believe that we promptly brought these charges once we were informed that the defendant was incarcerated. And so we would have requested the court dismiss the motion.
Mr. Kirker, when you say on October 27th, 2021, the charges were brought, was just a warrant authorization?
This was his period of incarceration on other charges for retail fraud, 2 counts of stolen property, motor vehicle, and 1 count of fleeing police activity. And he was sentenced to a term of 1 year, 7 months to 5 years.
So there's no, what I'm trying to understand, Attorney Salaka, where is this information about the charges being dismissed or potentially dismissed and reissued?
So, Your Honor, the only evidence that we have regarding that would be the, I guess, the empirical evidence regarding the, we have 1, 2, 3 lien checks after my client's incarceration at STS that turned up no felony charges in the system out of Wayne County. So whether the prosecution failed or determined that they didn't want to proceed, but again, Your Honor, these are issues that would have been issued. I wanted to establish for the record, but the prosecution fails to address the arguments made in my speedy trial and due process motion regarding, People versus Williams, when it says, where the delay is more than 18 months, the prosecution bears the responsibility of proving that the defendant is not prejudiced. Here, their length of delay is greater than 18 months. We have no explanation of the reason for the delay. The defendant has clearly asserted his right to a speedy trial. And as was demonstrated in People versus Williams, the presumption now is that my client is prejudiced. And so for the prosecution now to make an argument based on a 180-day notice and a motion that I chose to withdraw, these are fundamental constitutional rights under the Michigan State Constitution, but as well as the United States Constitution, that have not been addressed by the prosecution, Your Honor.
Mr. Parker, so this is the 2021 case.
Yes.
Everyone agrees that this is the 2021 case, and that's when the charges were brought, correct?
Yes, Your Honor.
Okay, so it's now 2023. And he's been incarcerated since what date, Mr. Salaka?
He's been incarcerated, and Mr. Evans, so I just want to make sure I have this correct. You've been incarcerated in MDOC since 12/21, correct?
Yeah, I've been incarcerated since July 8th, but I got to MDOC on 12/21/21. I bet, yeah, July 8th, 23. No, July 8th, 21, I'm sorry.
Okay. Mr. Parker, what? Okay, let me start off with this. Mr. Salaka, you're saying that MPOC has done how many checks or requests to see if there are any outstanding charges, warrants?
They had 3 lien checks prior to his release, his scheduled parole date. Those dates were 12/21 when he was first checked into MDOC, 1/5 of 2022, and 11/7 of 2022, Your Honor.
Memorandums.
Okay, Mr. Parker, do you have any idea if after those lien checks, there was nothing that showed up as?
I do not, Your Honor, because our first notice of it, from the 180-day notice, was on February 6, 2023. That's the first document notice we had.
From MDOC.
From MDOC.
So the problem, that's the question I have, Attorney Salaka. If MDOC did do lien checks, and that can be proven that they did, and there was nothing in the search that popped up, then I would dismiss, but I need proof of that.
So again, Your Honor, we do have, and again, so here is the issue, and Mr. Evans does have in his possession, and I believe I have a digital copy of it, statements from the MDOC and the parole board indicating that his lien check did not reveal any felony charges. He requested information on it because he knew that these charges had been brought against him, and their response was, if there were any felony charges, they would have been revealed in the lien check. And I can provide that response to you. He cited the MDOC, or I'm sorry, the parole board to confirm this information because he wanted to find out whether or not there were even any misdemeanor charges. And he was informed that misdemeanor charges would not be revealed on this check, only felony charges. And if there were no felony charges revealed, that means there were none pending against him. So there is a document stating that such, Your Honor.
Okay, I need the document before I can make a decision.
All right, let me see, make sure that I have that. So I will, I can forward this information, the documents that Mr. Evans does have in his possession directly to yours and Mr. Kirker's email. And I'm doing so right now, Your Honor.
Okay, Attorney Suwaka, I'm going to do a dismissal while we're waiting, okay?
Thank you, Your Honor.
We're on the record, this is People of the State of Michigan versus Dawn Michelle Lampley, case 2356490. Ms. Lampley is charged with 1 count of home invasion first degree, count 2, which is a misdemeanor assault or assault and battery, set for exam today. Appearances.
Alexander Kirker on behalf of the people, P86282.
Okay, good morning. If you may please report Sarah Robinson, P63181 from Ms. Dawn Lampley, who's present in court. Ma'am, please state your name.
Dawn Michelle Lampley.
Good morning.
Good morning.
Okay, are the people ready to proceed?
People are not, Your Honors. My understanding, the officer in charge is not able to get in contact with the necessary witnesses who have not here.
Vote to dismiss and remove Ms. Lampley's tether.
I will dismiss without prejudice as people are not ready to move forward. And also find a order to have the tether removed.
Thank you.
Record on this line. Okay, we're back on the record on Mr. Roosevelt Evans. Attorney Suwaka, I received your email as well as prosecutor, correct?
Correct.
Okay, all right, this is a notification or a response. I just have one page here from Records Office stating that your client did request a lien check. It said that lien checks are completed during the intake process at RGC and during parole or discharge charge processing. And that if felony warrants charges exist, that he will be notified and that misdemeanor warrants will not affect his release. That's not important. And then it says, if you believe that you have any outstanding misdemeanor warrants, so it's not relevant. Okay. So Attorney Salaka, based off of that, I am not inclined to dismiss.
I understand, Your Honor. Again, my access to the information is limited, but that's why I requested if you're not inclined to grant this, that we be given an opportunity to have an evidentiary hearing, because as you indicated, we would easily be able to verify whether or not these lien checks were performed. But again, Your Honor, respectfully, regardless of whether or not the lien checks were performed, it still does not validate or address the inability and the dereliction of the prosecutor's office to proceed on this case. With or without the 180-day notice, they have a responsibility to bring this case within 18 months, and that argument has still yet to be addressed by the prosecution here. Again, the burden now shifts to the prosecution to demonstrate that my client is not prejudiced by their failure to bring this case timely. And so, I'm sorry, Your Honor.
Isn't that off of the Williams case?
Yes, Your Honor.
Wasn't that case regarding the 180 rule, 180-day rule?
That addressed the 180-day rule, but again, there was the Waklowski case, where it demonstrates that their constitutional right to a speedy trial, which is different than under the Michigan 180-day rule, where the speedy trial violation has occurred, the charges must be dismissed with prejudice. And again, we can go to the types of prejudice and whatnot, but the burden here, due to the delay, now is on the prosecution to demonstrate that this delay will not prejudice my client. I don't know how that is, again, how we move past that being addressed.
Okay, so
again, so I
ahead. Go ahead.
So again, in People versus Collins and People versus Lewandowski, they both address that in Michigan, the prejudice to a defendant is presumed where the delay exceeds 18 months. And so they, in Lewandowski, court quoted People versus Bennett, the presumption is conclusive unless the prosecutor is able to demonstrate lack of prejudice to the defendant. So I think that we've discussed in my brief that the case that there's prejudice that's both presumed and actual to my client. There's evidence that is not available to my client regarding the actual arrest that was made and what those circumstances are. I don't understand how my client could possibly make a knowing defense of this prosecution here, given the delay.
Mr. Kirk, do you have any response to the 18 months?
To the 18 months delay?
18 months standard that Attorney Salaka, right?
Yes, Your Honor. I've read the motion and during reading it, I could not understand exactly where the defendant was saying that he was prejudiced. Vague assertions of lost witnesses, faded memories, or misplaced documents, which seems to be the only allegations in the brief, are insufficient. The brief also does not mention two other factors of the Parker v. Wingo factors for a speedy trial. Those being the reason for the delay which in this case we believe is the defendant's incarceration, and our lack of notice from MDOC. Since as we've stated, as soon as we got the notice from MDOC in February of 23, 36 days later, he was arraigned on these charges. And the assertion of the right is the final factor. And the defendant, in this case, has not asserted his rights until the day before the preliminary exam. As was stated in Barker v. Wingo, failure to assert the right will make it difficult for a defendant to prove he was denied a speedy trial. So we believe even on that basis, this motion should still be denied. Predominantly on the fact that the delay is attributable to the defendants being incarcerated since July of 21, and us not receiving notice of that until February of 23.
Okay, Attorney Salaka, I am going to deny the motion. My number one question I had after your submission was what was the reason for the delay? And I don't have enough or any evidence to show that it was the people's delay as to why he was not brought before this court. I have received an email from Mr. Kirker, the 100-day notice, and they received the information in February of this year, and the exam was scheduled for last month in April. Because there's no evidence that the people have delayed in any way. They did not know that the defendant was in the MDOC, but there was no proof that they knew that. And because the 180-day rule does not apply, the only other court rule on MCR 6.00 court for speedy trial would be section C that discusses delay in felony and misdemeanor cases. And this is regarding if the defendant has been incarcerated for a period of 180 days or more to answer for the same crime or crime based on the same conduct or arising from the same criminal episode. In this case, this is a completely different charge than the one that he's currently incarcerated for. So I do not have any evidence to show that the people delayed in Mr. Evans' incarceration. I'm going to dismiss or deny that motion.
Thank you, Your Honor. I simply have I guess this would be a housekeeping matter, because this warrant was that my client is currently being arraigned on is issued under a separate warrant number than his original warrant was issued. And so this warrant was actually renewed in order to bring this arraignment. So again, it could be, I really would like to get an evidentiary hearing to understand how possibly my client could have been performing, or MDOC could have been performing lien checks without, and again, if there's nothing there, I agree that you know, they didn't have, you know, that your ruling would be accurate. But if for whatever reason, this warrant was not in the system, it's to no fault of my client or the MDOC that the housekeeping of the Wayne County's prosecutor's office was not in order. And I'd simply like the ability to be able to understand how that the system that we rely upon to get our information did not have the accurate information.
Okay, Attorney Salaka, this is district court. We have certain responsibilities as far as probable cause hearings, and I believe that the evidentiary hearing would be more proper to be held at the Third Circuit if we're to be bound, because any more delay would then defeat this whole purpose.
Thank you, Your Honor.
So what I'd like to do is take you for an exam and In the event that it is bound over, I strongly suggest filing it with the third circuit judge and review that argument so that you have time and the resources to have a full investigation with the prosecutor's office as to whether or not there was a delay that I just don't see.
Okay, Your Honor. You let me know what day that we have for that you have available for an exam.
May 25th or 26th, either of those days work.
Yeah. 25th will be fine, Your Honor.
Okay, let me see what time. We do 9:30 or 10 o'clock.
9:30 will be fine, Your Honor.
Okay, Mr. Evans, we're scheduling your exam May 25th at 9 o'clock a.m. in person at 36th District Court. Okay? Oh, you're on mute. Can you give us a thumbs up to let me know you heard that date? Okay, Mr. Evans, thank you. Okay, we will make sure that there's a writ done for him to be in person on Zoom. You want to talk to your lawyer? Okay, I see you, Mr. Evans. We won't log off. Can someone unmute Mr. Evans' device, please?
Be patient.
I just want you to make sure, 'cause I don't have anything to write on. I got you, Joe.
Mr. Evans,
Yes, Your Honor.
I can hear you now. What's your question or comment?
Is there any way that I can do this on Zoom, Your Honor?
It has to be up to the prosecutor and the court. I don't mind it, but the prosecutor would have to be okay with it, as well as your lawyer, whether he advises you to do that.
Mr. Richard?
I always advise a client to go and have their exam in person, but again, that's your right.
Okay.
That's your right whether or not you want to do so.
Well, I'll go with your advice.
I know it's difficult, but if there's any questions or anything that comes up, it would be difficult for you to communicate with me at that time during the exam.
Okay, so Ms. Evans, you first. Huh?
Is it any way possible that it could be scheduled late in the day so I can be on a one-day writ?
We can do it at 1:30, that's fine.
So can we have me, is any way possible I could be burned down and brought back the same day, Your Honor? Any way possible? Because it's kind of hard. I have to be relocated and they pack me up and I lose all my stuff and it's like starting all over again.
We'll schedule it for 1:30, and if that means that you can go and come back in the same day, then fine. But 1:30 is the latest we can do in the afternoon. Because by union rules, we have to be done at 4:30 for staff. So I'll schedule it for 1:30 on the 25th, and then if that means you can do the same day writ, then fine. I don't have a problem with it.
Can I ask who authorized the one-day writ, Your Honor? I don't want to be a problem. I'm just trying to find out how that process works.
It would be your facility, and Wayne County Jail will have to agree to it.
Okay, so who do we request that to? I mean, are we making the request, Your Honor? Do I have to make the
The
request?
court will take care of it. We can do it, if it's possible, it'll be done. You don't have to do it.
All right, thank you, Your Honor. I don't mean to be a problem. I was trying to get understanding because they're not really communicating with me here.
Understood. We'll make the request.
Thank you.
You're welcome. Okay. May 25th at 1:30 PM. And you're all set, Mr. Evans.
Thank you, Your Honor. Have a good day.
Okay, Attorney Slaughter, see you on the 25th.
Thank you, Your Honor.
Even the same too.
People of the state of Michigan versus, I'm sorry. Okay, we're on the record as the people of the state of Michigan versus Alexander David Allen Jr. Case 2356325. Mr. Allen is charged with one kind of weapon carrying concealed set for an exam today. Appears.
Evidence of 12548 of the application.
Veronica Walrath, yes, E85665, on behalf of Mr. Allen, who is present in the courtroom behind me. Mr. Allen, if you could state your name for the record.
Good afternoon. Everyone ready to go?
Yes, Yes, Your Honor.
Yes.
Already.
Okay, there's anyone on Zoom who may be a witness on this case, or anyone on YouTube who may be a potential witness, now's your time to log off. Thank you for your first witness.
People call Officer Brandon Newman.
I wasn't talking about everyone come back to 1:30, just. Yeah, I don't know, no problem. You know, that- Not everyone. Not for you all at 1:30.
Say again?
I wasn't saying for you all at 1:30.
Oh,
That's why I just asked me to come out there, because I had a feeling. So I meant for the other cases, so we can hold yours. Okay. Okay, Judge Shelley, is it Judge? We have been here. I know that. Okay. But- Spread itself true. See right here. And the star microphone is the way it's- Whenever you're ready, just walk.
Officer, could you state your name for the record, please?
Officer Newman,
And you are an officer for what agency?
Detroit Police Department,
How long have you been with that agency?
for 3 years.
And were you on duty April 6th of this year?
Yes,
And were you on duty at 12800 West Nickel Road?
yes,
And that's in the city of Detroit, County, Wayne?
yes.
What were you doing at that location?
That's on patrol, special attention.
When you say special attention, what do you mean?
Some gas stations in the city of Detroit partner with the Detroit Police Department, under a green light location.
And what did you observe in that area on that day?
Gentlemen sitting on first, second row. Can't really.
I can really hear you, sir.
Yeah.
I can't hear you.
I thought it was me.
You asked the question, get a response to me. I couldn't hear that last.
Very good. Yes, Your Honor. In that location, what did you observe?
Observed the young gentleman wearing a white shirt, t-shirt here today.
Let the record reflect that the officer has identified the defendant.
So reflective.
And what was it that you observed about the defendant?
Observed the L-shaped print in his front pants pocket.
And what did you do at that time?
Exit our scout car.
And did you approach the defendant?
Yes, sir.
Did you have a discussion with the defendant?
Yes, sir.
What was that discussion?
I asked him if he had a CPO.
And what's the CPO?
It's a license to carry a concealed weapon.
And what was his answer?
Said no.
What happened at that time?
A gentleman was detained.
What happened after he was detained?
The handgun was removed of him.
Did you observe this?
Yes, sir.
Who removed the handgun?
My partner.
And your partner's name is Tyke Reed?
Yes, sir.
What type of weapon was it?
It's a handgun.
Can you describe it?
Black.
Also, I will have to look at my report, I believe. I'll have to look.
May I approach the witness? Yeah.
Thank you.
Review your report, refresh your recollection of the type.
Yes. Julius Arms,
And what happened to the weapon?
it's placed on evidence.
And taken into custody?
Yes.
I have nothing further, Your Honor.
So you said that special attention is something that happens when the gas station is partnered with green light and partnered with DPD. Does that mean that when you're on a special attention patrol, or rather, sorry, in this case, there was no call that brought you to that gas station?
No, ma'am.
Okay. And there was no prior information that you had gotten about the individual that you ended up detaining that caused your attention to be drawn? No phone call or no from the gas station employees?
No, ma'am.
Okay. And you were seated in the vehicle that you were patrolling in when you first saw him?
Yes.
Okay. And you observed a print or a bulge in his front pants pocket?
Yes.
Okay. He was wearing sweatpants, so that would be a fabric that can show a weight in it?
Yes.
Okay. An object like a cell phone or a wallet can cause a bulge in someone's pants pockets, correct?
Correct.
Okay. And that would be visible in that type of pants, right?
Correct.
Okay, so the fact that you can see a shape in someone's pants doesn't inherently indicate that they're participating in any illegal activity, right?
Correct.
Okay. But when you saw that bulge, you and your partner like got out of the car at the same time?
Correct.
Okay. And then you asked Mr. Allen if he had a CPL?
Correct.
Okay. He said that he did not have a CPL, correct?
Correct.
Okay. Did you ask him if he had a weapon?
No. No.
No, okay. And he was handcuffed prior to the removal of any weapon, correct?
Yes.
Okay. No further questions for this witness.
When you observed the bulge, what was its shape?
Tail.
So why is that significant?
Due to my experience in this position, I have that L-shaped bulge is consistent with the handcuff.
I have nothing further, Your Honor. You have no further. You have no further witness, Your Honor.
Any witnesses more than that? No, Your Honor.
People, motion that the defendant be bound over on count one, weapons of carrying concealed, reserve argument.
Your Honor, defense would oppose bind over in this case, as the officer has just testified. The entire reason for approaching Mr. Allen was a view of a bulge in his pocket, which can be caused by multiple legal things, a wallet, cell phones. There's no need to enumerate those items, but certainly you can have multiple items in a sweatpants pocket that fall in a way that could resemble a weapon, could resemble a wallet. That alone is not reasonable suspicion to approach a person and begin the process of detaining them, because it only shows that there was something in his pants pocket. There was no prior call. There was no other suspicious behavior. There was essentially no other reason for Mr. Allen to draw the attention of the police. Additionally, they asked him if he had a CPL, but they did not ask verbally if Mr. Allen had a weapon on his person. I don't have a weapon on my person, I don't have a CPL, and so I'm not permitting, since he doesn't currently. I think that the prosecution has not met the probable cause burden, because the stop, was done without any reasonable suspicion to initiate a stop. It has to be suppressed, and so the weapon and the stop itself are not admissible to that.
Your Honor, the officer testified, the fact that under his experience, an L-shaped bulge, indicates that there's a weapon. Except for a weapon, all other items that, defense counsel mentioned are all square, where a pistol would be an L shape. As far as whether the bulge isn't, is an L shape or is enough, that's a question of fact. And, matter should be bound over on count one, weapons carrying and concealed. Thank you.
And the court heard testimony from one officer, Officer Newman, who testified that he saw the defendant with the L shape bulge in his sweatpants. That was the only thing they observed. There was nothing else, no other circumstances, no other facts to assist in the decision here to determine whether or not Officer Newman was correct in how he sees the gun from the defendant. I don't think there's sufficient evidence here. Bulge is not enough. After asking if he had a CPL, says he's been detained and handcuffed removed from him. There was no other discussion. There was nothing else other than a bulge, and that's not enough based on the case law.
Stand up, sir.
I'm very aware that it may be appealed, but that's what the higher courts are for. So I'm dismissing without. Thank you, Your Honor.
Thank you, Your Honor.
President Belzer.
You didn't do it.
Oh, this one. Come on.
Okay, we're on the record as people of Center, Michigan versus Eric Belson, case 2260641. Mr. Belson is charged with count one, assault with intent to do great bodily harm less than murder or by strangulation. Count two, weapons, dangerous weapon, mislaid, set for example, appearances.
Alexander Kirker on behalf of the people, P86282.
I'm more about that. That's Christopher Quinn, P69483, apparently, Mr. Belser, who's present.
Belson, you take the floor, please.
Eric Don Belser.
Are people ready to proceed?
They're not, Your Honor, the necessary witnesses failed to appear.
I'll dismiss without prejudice as the people are not ready to move forward. I'll second Belson.
On my tongue. Oh, he did a water.
I'll do it after.
I got it.
Yeah, they need signature. Yours is yours, sir.
This one.
Yeah, that's yours. Right. And then this one is a signature. Both of them.
He can just wait outside.
Yes.
Yeah. Yep.
Oh, one of them is for this one.
We did already. Adjourn the bank, PCC.
Well, we did it on the record already.
For Katie. Was that the way you testified, her? You said that we do watch and remember nobody had. Well, that's. I'm sorry.
Okay. Deion Watson. Case 23562. One. People of the State of Michigan versus Deion William Watson. Count one, weapons, firearms, possession by felon. Count two, weapons, ammunition, possession by felon. Count three, weapons carrying concealed. Count 4, 5, weapons, only firearm with the visual offender. Fourth offense notice set for a probable cause conference today. Harrison.
Everyone's Milwaukee, P5488, people.
No defense counsel showed up today, nor did the defendant anything from.
People would ask for a KPS, Your Honor.
Okay, there was PCC adjourned from May 1st, so that counsel could find the defendant, he still not been found. I will be entering a KPS 1,000 cash and surety. Okay, next we have people of the State of Michigan versus Lorenzo Ian Myers, 2156698. Mr. Demeyers is charged with one-time stolen property, receiving a motor vehicle set for a probable cause conference today. Harrison.
Edwin Milwaukee, P5488, we have people.
And just for the record, defense counsel did log in, not at 8:30, via the chat. And I asked if she wanted to wait. Attorney Alyssa Segura. And I said that we were at exam, and I would call it after we're done. And KPS him on the record, and I would know that you were here and haven't been able to find him. She said, I appreciate that, Your Honor. However, any chance I can have another PCC date to get in contact with him. My investigator just gave me a few numbers to call. This is an old case, 2021, and the number we had on file is home. Counsel is not logged back on. I did receive a request for another date. Speaking with people.
We would ask for a KPS, Your Honor.
I will be KPSing this defendant for the simple fact that he has Asian history and has been arraigned again and did not show up once again. So it'll be $1,000 cash insurance. Lastly, we have people of the State of Michigan versus Dwight Richard Dobbins, 2355862. Mr. Dobbins is charged count one, and only count one, weapons carrying concealed set for a probable cause.
Everyone's Milwaukee, P5488, we have people.
And no defense counsel or defendant, anything from the people.
Ask for a KPS, Your Honor.
Okay, no KPS history on this one, so it'll be 1,000 personal. That's it for KPS.
Thank you, Your Honor.
Thank you.
KPS demise too.
You need to.
How much?
Yeah, Wednesday.
Wednesday, I got you.
1,000 cash or This is case 2356564, the people of the state of Michigan versus the Caven Jemison, charged with one count of controlled substances, possession of cocaine, heroin, or another narcotic less than 25 grams, 1047.
Alexander Kirker on behalf of the vehicle P86282.
William Glenn on behalf of Mr. Jemison, P3679.
Sir, can you state your name for the record, please?
KB Jemison.
Good afternoon. Okay, is everyone ready to proceed?
Yes, Your Honor.
Okay, if there's anyone, I'm sorry, what you saying?
Move to sequester.
Okay, if there's anyone on YouTube or on Zoom who may be watching, to be a potential witness on this case, now is their time to log off. In the courtroom, there's no one present, should you hear the staff, Mr. Jemison, with that, call you first witness.
Your Honor, before that, we just have.
Oh, I'm sorry, I'm just speeding. Any other preliminary matters?
Yes, Your Honor, this time the people move to admit it pursuant to MCL 76611E1A, a preliminary drug analysis with log seal number N0075490007, stating that the suspected amphetamine recovered tested positive for 17.6 grams of fentanyl.
For exam purposes only.
For exam purposes only, okay, so you'll be admitted as people of exhibit 1.
May I approach him?
Yes. Anything else?
People.
Now you call your first.
Some people call Officer Charles Brodsky.
Call the court of announcement. Swear to tell the truth, the truth.
Yes.
Right here. Are you ready, Mr. Kirk?
Could you please restate your name for the record?
Charles Brodsky. Sorry, very loud.
And are you currently employed?
Yes,
Where are you currently employed?
Detroit Police Department,
And in what capacity?
police officer,
How long have you been employed as a police officer?
about 5 years.
And were you employed as a police officer on April 21st, 2023?
Yes,
Did you in fact work on that date?
yes,
Were you by yourself or with a partner?
that was my whole crew.
And who are the officers in this crew?
So narcotics team,
And roughly how many officers are in this team?
10 to 12.
And did your duties as a police officer take you to an area at or near 15004 Paramount Drive?
Yes,
Is that in the city of Detroit, county of Wayne?
yes,
And what brought you to that area?
the execution of a search warrant.
And what happens when you executed the search warrant?
As far as what?
As far as what happened when you arrived on the location?
We made entry into the location,
And what is making entry involved?
knocking and announcing, and within making entry into the location.
And what happens when you announce an announcement, did anybody respond?
I wasn't part of the knock and announce, so I cannot put it.
Did you enter the
I did.
location? And what happened when you entered the location?
So we made the entrance to the location and ordered everyone that was inside down and people were detained.
And how many people were in this location?
That I don't know.
Is anybody in the courtroom today present who was there when you executed the search warrant?
Yes.
Could you please point out that individual and identify the article of clothing they're wearing?
Orange camo shirt.
Reflect the identification of the defendants. And where did you observe the defendants?
The front living room area.
And what happens when you encounter the defendants?
I didn't encounter many people. He was already in handcuffs when I. So.
Okay. And after the defendants, and were the others in the location detained as well?
Yes.
After everyone was detained, what happened?
I was assigned to the search and recovery inside the location.
Okay. And did you make any recoveries?
I did.
And do you recall where you made the recoveries?
In the kitchen.
And where in the kitchen?
The counter and the drawer right next to the sink.
Is it floor?
Yes. Sorry.
And what did you recover from that drawer?
U.S. currency and narcotics.
And could you describe those narcotics?
There was a few knotted bags of assorted pills.
And when you say knotted bags, what do you mean by that?
They were like sandwich bags with a knot tied on them.
And in your experience, what is the significance of this packaging? If any. And can you describe the items that were inside of the bag?
There was an assortment of different pills.
And what did you do when you recovered these items?
We packaged them up in like an envelope and take them to PPU where they get tested.
Can you describe the color of any of the
Well,
items?
there was multiple different colored pills. There was a few different bags of different types of pills. So
And were they all pills?
yes.
And were the items placed into evidence?
Yes.
Do you recall the lock seal number?
Not off the top of my head.
Reviewing your report, refresh your recollection?
Yes.
Your Honor, may I approach?
Yes.
Yes, just let pull the evidence back.
The tag number.
Yes.
So the report number one.
State that. Well, let me know.
So we,
Do you recall the evidence tag number?
yeah, the report number is 23042100175.1.
No further questions.
Well, sir, now when you went into this house, you stated that you saw Mr. Jemison in the living room, is that correct?
Yes.
He was in handcuffs, is that correct?
Yes.
Now, you stated that there were other people inside the house. How many people inside the house again?
I don't know.
Isn't it true that your unit issued loitering tickets to some of the people inside the house?
Yes, from inside and outside of the house.
Now, as far as any drugs in the kitchen, did you see Mr. Jemison have any drugs in the kitchen?
No.
Were there any drugs on his person in there?
No, that I'm aware of.
Nothing.
Can you read the rest?
Oh, yeah, so this time people call Officer Lamar Kelsey. Please state your name for the record,
Detroit Police Officer Lamar Kelsey.
and you said you were a police officer?
Yes,
How long have you been employed as a police officer?
almost 7 years.
And were you employed as a police officer on April 21st, 2023?
Yes,
Did you in fact work on that date?
yes,
And did your duties as a police officer take you to an area at or near 15004 Paramount Drive?
yes,
That's in the city of Detroit, County of Wayne?
yes.
And what brought you to that area?
We're executing a search warrant.
And what was your role in executing the search warrant?
At that time, I was part of the rear or perimeter security at the time.
And what does that entail?
I don't make entry into the house. I'm on the outside of the house.
And at any point, did you make entry into the house?
Yes.
And when was that?
After this, either Sergeant Jackson or Sergeant Briggs made the location safe and secure for us to enter.
And what happened when you entered the location?
I assisted with searching the location for narcotics or any weapons. And, I was searching people inside the location.
And when you said people, how many people were inside this location?
Off the top of my head, I cannot give you a solid number.
Do you have a rough estimate of how many people?
It was more than 3. So, yeah.
And did you make any recoveries?
No.
And do you see anybody in the courtroom today that you came into contact with on that date?
Yes, the defendant sitting next to his attorney.
Can you point out and identify articles?
Like brown pants, yellow, black, orange, Nikes, camouflage, brown, white, black, sweatshirt.
Round of the record, like the identification of the defendants. And did you have an opportunity to speak with the defendants?
Not one-on-one, like an interrogation or anything. He was in the living room area. And he just stated that the back southeast bedroom was his. They had property inside that room. He said he doesn't own the location. He said he was just renting the room.
Backside bedroom?
I believe it was southeast bedroom.
And he said that he resides at the location?
Yeah, he said he was renting that room, but he does have property inside the location, inside the room also.
Did he say what property he has?
Off the top of my head, I can't recall.
no further questions.
Officer, when you stated that, you went to this place, you were at the perimeter or the back end unit?
The initial, yes.
Right. Now, when the search warrant was executed, did you see anybody run from the house or jump out of the windows or?
Yeah.
How many people did you see run out of the house?
2.
Did you catch any?
1.
Now, were there any loitering tickets issued that day?
Wait a minute. Off the top of my head, it was multiple people there. They probably did write tickets.
Okay, how many loitering tickets do you remember?
I cannot confirm that.
Now, did you confiscate any drugs or narcotics or any type of paraphernalia from Mr. Jemison?
No, I did not.
Nothing.
I have nothing further. No other witnesses from the people.
No, Your Honor.
At this time, the people have moved to bind over the defendants on count 1, controlled substance possession, less than 25 grams. As we heard from the first witness, he made entry with the after knocking and announcing. Knocking and announcing inside. Once inside the location, he was able to make several recoveries. These would be in the kitchen, in the drawer next to the sink. The witness described recovering U.S. currency and narcotics. Narcotics consisted of an assortment of pills, all different colors, which the preliminary analysis that was admitted stated tested positive for 17.6 grams of fentanyl. The second witness, who was part of the rear security but then entered the location later, encountered the defendants. We heard the defendants make several statements, one of which was that the back southeast bedroom was his, that he rents the room and has some property there. People believe that there is enough for constructive possession, that the defendants had dominion and control over the kitchen area and could access it. We believe that the burden of probable cause has been met and moved to bind the minister.
Yeah, no, I would object. My client was arrested at this location, but the testimony from 2 officers here today stated that when they got there, he was already in custody. When they executed the warrant, there was testimony that at least 2 people left the place. 1 person was caught. There were at least 3 people or more people inside the location. Although they found drugs in the kitchen area, there's no testimony that any of these narcotics were found on my client's person or in the back bedroom when he said he rented. I don't believe that the people have presented enough for a question of fact or trial of fact to bind this case over, and I would object.
And simply the defendant does not have to have literal possession of the drugs, but has to have legal rights to them. As somebody who's admitted that he rents this building, I believe there's a question of fact as to whether he had possession of items recovered in the kitchen of this building.
This will be a question of fact regarding possession. The testimony that the defendant, from his own statement, lived in the location, had a room that was described as the southeast bedroom, and that he was just renting a room there. The drugs were found in the common area. And probable cause standard, constructive possession can be established here. That since it's in a common area, the defendant knew of the drugs and had the right to control those drugs at some point. And with the stipulation to the entry of the controlled substance analysis, the people have met its burden of proof that the probable cause standard to find the defendant over for an arraignment on the information. It'll be 2 weeks from today, since we're out of custody, May 22nd, 9:05 a.m. Mr. Jefferson, did you get that date?
I get
So 2 weeks from today, at Frank Market Hall of Justice, 9:05.
The day of like 22nd one. That's what I'm talking about. All right, thank you.
Am I right? All right, you can't lose the paper. Welcome, Mr. Jenkins.
Thank you.
All right. Be good, all right?
Yes, sir.
Oh, Jefferson. I'm bad. Jenkins.
I told him, or should we? Yep, it's right here. All right.
How you doing?
How about yourself? Okay. Hello, hello.
Yeah.
Yeah.
Yeah, for sure. We have two lawyers though. That's the thing.
Oh, okay.
we're on the record, the people of Michigan. Latoya, that voice. Defendant number 2, Lisa Shea Marshall, defendant number 1 on case 2355796. Both are charged with count 1, forgery of document affecting real property. Count 2, uttering and publishing a document affecting real property. Count 3, false pretenses, $1,000 or more or less than $20,000, and habitual offender fourth offense notice for offense number 2, and habitual offender third offense notice for number 1, set for an examination.
Good afternoon, Your Honor. Latoya Willis, occurring on behalf of the people.
Good afternoon, Your Honor. Attorney Brent Jaffe on behalf of Lisa Marshall, present.
Judge, good afternoon to you and your staff. Lilia Diallo, P52026. On behalf of Ms. Boyce, who is directly behind me, present, we are ready to proceed, but ask the court to make we're making a motion for an order of sequestration.
People will join in that motion, asking in exception for the officer in charge, Detective Williams Jones, who is present. Any objection?
None.
Your Honor, I would say if Ms. Jones is going to be testifying, then I would object.
No testify. And Ms. Marshall, can you state your full name for the record?
Keisha Marshall.
And Ms. Boyce.
Latoya Boyce.
If there's anyone on YouTube or Zoom who may be testifying in this case, now their time to log off. And there's no one in the courtroom who should be here. So with that, give you all the first word.
Thank you, Judge.
Raise your right hand. You swear to tell the truth. Have a seat. Make sure you speak up to the microphone.
Thank you. Good afternoon. Please tell us all your full name.
Michelle Rashida.
All right, Ms. Whiters, I want to ask you some questions about a house located at 16157 Earlwood Street. Are you familiar with that location?
Yes.
And is that a single family home? And is that located in the city of Detroit?
Yes.
And how are you familiar with that property?
My grandparents.
And when you say your grandparents' home, who does it belong to?
Well, currently it belongs to my father, but my grandparents passed. My grandfather passed, and my grandmother passed.
And your father's name?
Michael Hart.
Michael Hart.
So Judge, I guess just foundationally, if we can, get foundationally figure out who has it, who has title and all of that good stuff right now. I think that's the question.
So the last person to own the property was
Michael Hart.
All right. And back in September of 2022, did you make a complaint with the mortgage and deed fraud section?
Yes, I made it September 2021.
Okay, and what was the
I'm
complaint?
going to direct that as non-responsive to the question, actually. The question was 2022, and the response should have been no. If there was a follow-up question, then perhaps that'd be the next step, but it's non-responsive to that.
What was the complaint regarding?
A fraudulent deed.
And
so Judge, you can take it for what it is, right? It's conclusory, so just foundational, and I'm not gonna, I don't believe in just jumping up for no reason, but foundational deed, where's the deed, right? But that's the best evidence, but, as far as what we're talking about, Right, I just need a little bit of foundation so that I can keep track with my notes, okay? That's the only thing. Thank you.
I'll ask. At some point, were you looking into the property located on Birdwood?
At some point, was I?
Were you looking into it?
Yes.
All right. And when you were looking into it, where were you looking?
I'm not understanding what you're asking.
Did you come across some paperwork regarding the Birdwood address?
Oh, no.
How did you become aware that there was a discrepancy in the title?
The neighbors on Birdwood.
Yeah, I'm sorry, I'm gonna object here on this leading question. There's been nothing that submitted in any capacity that there's a discrepancy in any title. We don't know if there's title to anything. That's a leading question.
I believe she said that in 21, she made a complaint for deed fraud.
Yes.
Which isn't necessarily part and parcel of that issue. So.
Okay, I better respond to that.
As far to his objection.
I don't really understand what the objection is, honestly. Question, I don't understand that objection.
Jackie, what's the objection?
I'll save it for cross-examination. Your Honor.
How did you become aware of the discrepancy in the title?
September 2021, the neighbors across the street from my grandmother's house called.
All right.
They told me that.
Okay, you can't tell us what they told you.
Okay.
Based on what they told you.
Based on what they told me, I went home and I called fraudulent. I called and I emailed. And I got the telephone, I called the fraudulent, the fraudulent hotline, whatever, for Wayne County.
All right.
I got a telephone call from the office.
Okay.
From Michael Burchard. He asked me to come down.
All right, and did you go down to the office?
Yes.
And when you went down to the office, did you make the complaint?
Yes, sir.
Were you presented or shown any paperwork or title work for the property?
Yes, sir.
All right. Permission to approach with what's been marked as People's Proposed Exhibit 1. Yes. Thank you. Handing you what's been marked as People's Proposed Exhibit 1. Have I handed you a copy of a quick claim deed?
Yes.
All right, and is that a quick claim deed that you have seen before?
Yes.
Is that a quick claim deed in relation to the Birdwood property?
Yes, it is.
All right, and is that the title work or paper that you saw when you went down to the deed fraud section?
Yes.
People would move to admit People's Proposed Exhibit 1 and 2.
I can't, if I knew how, I would, Judge.
It'll be admitted as People's Exhibit 1.
Thank you. Now, the deed purports to convey the property from Michael Hardeman to another individual. Is that correct?
Yes.
All right, and the signature that's located on that deed for Mr. Michael Hardeman. Well, let me go back. You said that Mr. Hardeman was your father?
Yes.
All right, and for how long was Mr. Hardeman your father before he passed away?
52 years.
All right. And over the course of those 52 years, did you have an opportunity to see your father's signature?
Oh, multiple. Yes.
And the signature that purports to be his on that quick claim deed there, does it look to be his?
No, ma'am.
Is there anything that stands out to you about the signature?
Oh, yes.
Can you just, the spelling of the name, does it appear to be your father's appropriate spelling?
No.
The date on the deed, can you tell the court what that date is?
April 1st, 2002.
All right. Now, when was it that your father passed away?
September 5th.
Of what year?
2021.
2021. All right, so during the time that this deed is dated, your father was alive?
Yes.
Did he ever indicate to you that he had transferred that property to anyone?
No.
The date, do you see the barcode up top?
Yes.
Can you see the date that's above that?
Yes.
What's the date on that?
September 30th, 2021.
After your father passed in April of 2020, what happened with the property?
My father passed September.
I'm sorry,
2021.
September of 2021. What happened with the property?
Like what do you mean?
Was there anyone living in it?
No.
Was there, food? So was it vacant?
Yes.
And was it vacant through September 30th of 2021? Do you know any of the individuals named on the deed other than your father?
No.
No additional questions?
Thank you, Judge.
Okay.
Now, a couple of questions. It's your testimony that, again, your father passed away in September of 2021, correct? Okay, and prior to passing away, he resided in that property?
No.
Oh, he did not reside there? No. Okay, and to your knowledge, does anyone reside there?
No.
Okay. You don't know, correct?
No one resided in.
How do you know that?
Because I had keys to the property. I went to the property with my father for months.
Okay, you were checking on the property?
Yes.
Okay. And again, while he's still alive, again, based on the deed that's been submitted, the property is transferred to someone else, is that correct?
Based on it?
Yes.
Yes.
And I guess my last question would be that the property was never transferred to you, correct?
Correct.
Yes, you have no legal interest or, excuse me, legal standing with regards to this property, correct?
Objection. Relevance and it calls for legal conclusion. As an heir, she would automatically have this property.
If I can respond, because that's incorrect, as an heir, she would automatically have anything. So I disagree with that. So anyway, but I can re-ask the question.
Okay.
And did your father have a will?
No.
Okay. And have you ever received any paperwork that would state that you are the lawful owner or of this property?
No.
Okay, nothing further, thank you.
One question. Where was your father living back in April 1st of 2020 when the deed was drafted?
Lived with me.
He lived with you?
Yes.
All right. Thank you.
Thank you.
How you doing?
Make sure you turn yellow saying she's okay.
Yeah, she's good.
Oh. Oh. Got it.
What's happening?
Yellow in the hallway. Right. I'm sorry. I do. Turn the yellow back.
I'm ready.
Please tell us all your name.
And the chief.
Chief. Ms. Chief, what is your age?
30.
I want to ask you some questions. About a property located at 16157 Burwood Street. Are you familiar with that property?
Yeah.
All right, now at some point, were you looking for housing?
Yeah.
And when would that have been approximately?
Like around, I started looking in like 2020, really.
And do you recall about what month? Was it summer, spring, fall, winter?
Winter.
Winter of 2020, okay. And
Yes.
is that correct?
Yes.
And when you began looking for a property, where was it that you were working?
At Hollywood.
And when you worked there, did you work with anyone that you see here in court today?
Yes.
Who would it have been?
Pizza.
You said Kisa and
Yeah.
okay, can you point to
But I
that?
didn't start working with them until 21. I started looking for housing in 20, but I started working with them until 21.
Okay. And the persons that you have said, Kisa and Toya, can you just point to them individually in the court? Kisa, I'm sorry.
Pizza and joy.
All right, for the record, the witness has identified the defendants. With the record,
All right.
thank you. Now, you started working with the defendants in sometime in 2021. And did you all have any conversations about you trying to find housing?
Yeah.
All right, what were those conversations about?
Well, I really was talking to them about my personal situation. And as we were talking about it, they told me that they knew someone who would help.
All right, and when you say they, are you referring to the both of them?
Yes.
And who did they tell you that they knew could help?
They never said the person's name.
Did they say where the person
Your Honor,
worked?
Judge, we can refrain from using refrain from using pronouns. It would specify exactly who's saying what at what time, please.
So when you say, instead of saying they,
Keep the employee never told me the person's name.
okay, did either of them tell you where that person worked?
I was mistaken as with Detroit Land Bank, so I was told for Detroit Land Bank.
So you were told that the two of them knew someone from the Detroit Land
Wait a
Bank?
minute, wait, hold on, I might have missed something. We talking about hearsay? Objection hearsay? By told by who?
I have no idea.
I've been told
Oh,
by. The objection is that you're not going to say.
hearsay.
Okay, but I'll let you respond. Statements from the defendant would not be hearsay. You indicated that the statements were from Kisa and Toya.
But see,
That's incorrect, by the way. That's mischaracterization of testimony. That's not what testimony said. She said that I was told. That's all she said. She said I was told. It was never specified. So perhaps ask her directly who she was told this by, to be more specific.
Okay, can you clarify who said what about the land bank? People in Toya.
Keisha and Toya, what?
Keisha and Toya told me, that they was gonna come one with Detroit Land Bank, because we all work together.
All right. And Keisha and Toya told you that they knew someone from the Detroit Land Bank.
Yeah.
And what was this person from the Detroit Land Bank supposed to do for you or could do for you?
From what I was told that.
By who?
Keisha and Toya.
Okay.
That I.
Well, hold on, can we just say, and my only objection is, if you could say who said what, when, Judge, right? Because I don't know what's going on with this case, because I understand statements, right?
Okay, so they're not Siamese twins and talking.
Right, they can't talk together.
They were talking at the same time, they were talking to, they were next to each other, so I mean, okay. I don't want to know if they was repeating the same thing to each other, repeating the same thing to me at one time, but they were standing right next to each other, and they knew the person who was there, so I'm not understanding how y'all really want me to answer that question, because you're both there.
So the conversation that you're having with them, the conversation that you have with them about the property, it's the three of you together?
The three of us together.
And it's the three of you together that are having this back and forth conversation?
Yes.
All right, and when the person from the land bank is proposed to you, is that a proposition that's made to you by one or by both of them?
Both.
Okay. All right.
Just answer the question to your best ability.
And when Keisha and Toya tell you about the person from the land bank, what exactly is told to you?
They pretty much was like.
I'm gonna object to hearsay because we don't know who the they is. If she could say exactly who she's talking about, perhaps, but she to put it under this umbrella of they, protect herself up here under from any hearsay objections, most respectfully, Your Honor, is not appropriate. So that's my objection, Your Honor.
Well, it wouldn't be hearsay, but you said Keisha and Toya, right?
So are they talking at the same time? When
But they're both defendants, so it's hearsay.
Agree, but in terms of what one would say to the other, but one co-defendant says that the other, it would be hearsay as far as I'm concerned. Because my client is not the other, is not the co-defendant, so I'm saying, that'd be my objection. Who's saying what when? That's the question, Your Honor.
I would just ask again, if you instead of the they, just if it's Keisha and Toya, say Keisha and Toya. All right. So when the proposal about the land bank person is presented to you, is that something that's told to you by both or just one?
Keisha and Toya.
And what does Keisha and Toya tell you about that person?
That they know from Detroit Land Bank and that they can help me find the house, pretty much.
And when Keisha and Toya tell you that, what do you do?
Okay.
You say, okay? All right. Now, how do you find out about the property that's on Birdwood Street?
Keisha and Toya approached me.
Is that after you talk to them about the person that they know at the Detroit Land Bank?
Yeah.
And when they approach you about the Birdwood property specifically, do you go and see that property?
Yeah.
Who do you go and see the property with?
Keisha and Toya.
They're both with you?
They're both with me.
All right, and
Just at the first time.
okay, and when you first go and see the property, is that in, do you know what year that's in?
2021.
Okay, and when you first go and see the property, do you go inside the property?
Yeah.
Who goes inside the property with you?
Keisha and Toya.
And do you know how you get inside? Do you see how you get inside this property?
It was open.
It was already open? And when you go inside of the property, what's the condition of it?
Well, it had like pictures and stuff, but it had things up, but like the ceiling was falling and things like that of that sort. It wasn't like in a horrible condition.
Okay, and you said there are pictures up, so does it appear to be furnished to you?
It was furnished.
And when you look around this place on Birdwood Street, what do you decide to do?
That I wanted to go through with the house.
When you say go through, you wanted to buy it?
Yeah, I wanted to buy the house.
All right. And when you decide that you want to buy it, do you find out, does anybody tell you how much it will be to buy the house?
Well, only thing that was told for me by Keisha and Toya is that it was gonna be $5,000 for the house. And I gave you $3,000.
Okay, so hold on. So Keisha and Toya both tell you that it's $5,000 for the house?
Yeah.
Do they tell you who you're going to pay for the house?
Not directly, not the direct person who I'm handing my money to.
So when they tell you, when Keisha and Toya tell you that it's $5,000 for the house, do you eventually at some point pay money for the house?
Yeah.
Who do you pay money to?
Keisha.
Okay. Now, how long after going to the house on Birdwood, Keisha and Toya, do you decide, do you pay the money for the house?
I paid the first amount before I got the deed. $3,000.
Well, how long after you went to the house did you pay for the house?
Your objection at this point is assuming that's not evidence in terms of this witness, so that's not objection.
What?
There's a lack of foundation at this point, right? She paid the money before she got the deed. We heard nothing, no information in terms of her getting any kind of deed or anything for that matter. So it's a lack of foundation at this point.
You said she got paid the first amount for the deed.
Before the deed, that assumes that we're talking that there's a deed in place that we're discussing right now, which hasn't been established at this point. So
But she testified, not the prosecutor. She said that she got it.
so then I would say at this point, assuming facts not evidence at this point with regards to this witness, that'd be my objection. Your Honor.
I don't know how she could be assuming facts and not in evidence when she's the person testifying, putting the facts into evidence.
I'm gonna overrule. The question was not leading as to whether or not she received the deed for after payment. The witness said she paid the $3,000 for the deed. We're giving to you, right?
Do you recall how long it was after you first went over and looked at that property that you paid the $3,000?
So I paid the $3,000 before I even really seen the property.
Okay, so before you went over to Birdwood Street, you paid $3,000?
Yes.
To whom?
Keisha.
And when you made that payment to Keisha, were you all still working together?
Me and Keisha was, yeah.
Was Keisha by herself when you made the $3,000 payment?
Yeah.
All right, now, after you make the $3,000 payment to Keisha, is that when you go over to the house with Keisha and Toya?
Yeah.
All right. And after you look at the house, after you pay the $3,000, do you pay any additional? And how much more money do you pay?
$1,000 after I got the deed.
Who do you? What was the last thing you just said?
I said in my hand.
When you in your hand. Who do you pay the $1,000 to?
Keisha.
And after you make the payment of $1,000 to Keisha, do you receive anything in paperwork?
The deed.
Who did you receive the deed from?
Keisha.
Are you having any further contact with Toya?
No, not really. No, not really. I mean, I don't want to put it, Keisha was more having contact with her.
Objection, foundation.
I didn't hear what she said. Keisha was having more contact with her? Okay.
Having more contact with Toya.
What about with you?
I'm sorry, you got it.
No,
No.
not really. Not really. After so long, after I guess maybe Keisha gave Toya the money.
Okay.
Say that again. Okay, yeah.
I'm going to scratch that from the record,
Thank
allow
you.
you to ask the question.
All right, you said somebody told you that they gave the money to Toya, is that what you just said?
I'm assuming that Keisha
You were,
gave.
okay, don't assume. I want to only, you can only testify to things that you know specifically, or things that either one of these defendants have said to you. All right, So did someone tell you that, or did you just do that? All right, now, after you paid the $1,000 for Keith, and you get the deed, you said you got the deed from Keith, all right, and once you get the deed, did you, take it down to be recorded?
Yeah.
Who told you to take it down and record it?
They both did. Pizza is.
Objection, Your Honor, leading question. Leading question, Your Honor. Who told you to go take it down and get recorded is a leading question. The question is, did you record it? If so, how? Not who told you. Leading question, Your Honor.
I object. I don't believe that's a leading question. It doesn't suggest an answer. It's not a specific answer to that question. Either yes, no, or somebody told me who to record it.
Someone told her to record it? How to record it? Yeah, we both.
Oh, okay. I'm gonna overrule.
Your Honor, Your Honor,
The question is who?
with all due respect, Your Honor, that if I can respond to the prosecutor's response. No one mentioned anything about recording, and the question was, who told you to record it?
Before that question.
There was no language as far as recording the deed prior to that question. That was my objection. That's all.
You indicated that you recorded the deed.
Yeah.
How did you know to record it?
The employer told me where I had to go to record the deed.
All right, and so both of them told you where to go to record the deed?
Yeah.
Permission to approach was admitted, People's Exhibit 1. Yes, thank you. Mr. Chief, I've handed you a copy of People's Exhibit 1. Do you recognize that document?
Yes, it's the deed for
all right, and is that the deed that you received, Kisa?
Yes.
And you indicated that you recorded that deed with the Wayne. Where did you record the deed?
I'm guessing it's the McCollum building, I guess. I don't know the deed office, the place you're supposed to go to.
Do you remember where it was? Was it?
I think it's in the, well, I'm for sure it's in the, McCollum building. The building that got the statue.
I can't look against it. The building that has the statue.
The McCollum building or Coleman Young building, one of them.
Do you recall what floor you went to? Nevertheless, you took the document somewhere downtown?
Yes.
And you said that you recorded?
Yes.
All right. And did you, how long after you received this deed did you record it?
Probably like a week.
Okay. Yeah, okay, okay, I'm sorry. Thank you, Judge. Okay. So about a week after you received the deed, you recorded it?
Yes.
All right. Did you ever have any contact with this supposed person from the land bank?
No.
And when you paid the money for the property, did you believe that it was a legitimate purchase?
Yes.
Did you meet any of the individuals that are named on that deed?
No.
No. Do you know Michael Hardiman?
No.
Do you know the notary that's on the deed?
No, I'm not.
And at some point, did you become aware that the property belonged to someone else?
After that.
Right. How did that happen?
After the people who own the house started coming by the house, shaking the house.
No objection here, sir.
So did you, I'm sorry. Did you go to the property?
I was the property, yes.
All right, and did you ever move into the property?
No.
Did you attempt to go in to the property and do anything inside the property?
Yes,
All right, and when you went inside the property, were you approached by anyone?
at first, the neighbor across the street.
All right. And were you approached by anyone else at another point?
Yeah,
Who would that have been?
it was the daughter of the owner of the house.
And after being approached by those individuals, did you have some concern about whether or not you actually owned the house?
Yeah.
And when you had those concerns, did you talk to Kisa or Toya about that?
Yeah,
Who did you speak to?
both Keisha and Toya.
And what did you tell them?
I told them that these people saying that the house doesn't belong to me, so I'm.
Your
just trying-
objection again, hearsay, Your Honor.
This is what she's saying, so. This is what you're saying?
That these people are saying to me, the house doesn't belong to me, is hearsay, Your Honor.
I don't know their name.
That's still hearsay, Your Honor.
It's not being offered for the truth of the matter asserted, it's being offered for the entire scenario, but it's her statement to the defendant so that the context of what's said to her in return can have some context.
Hearsay within, it's hearsay from what she's repeating from the neighbors. That she's saying to the defendant.
It's not being offered for the truth of the matter asserted.
Yes, it is. That's like why we're hearing now, for that issue. So it is being offered, the truth of the matter being asserted.
When you talked to Kisa and Toya, did you express your concerns about the property?
Yes.
And what did Kisa or Toya say in return?
They, in so many
Who
words,
say?
Keisha and Toya, in so many words, told me, don't worry about it, it's gonna be okay.
Yeah, it calls for speculation, Your Honor. I don't know what in so many words means, Your Honor. This is a court of law. I'm not sure what so many words mean. So if she knows, and she doesn't know, that's also an answer. So that's my objection. It calls for speculation, Your Honor.
I would disagree. I don't believe it's cause for speculation. It's a summary of what the defendant said to her. So
That's exactly what they said too.
do you recall
But they
exactly?
just told me that don't worry about it, it'll be okay. It'll be all right, just, you have the deed to the house, so you don't have anything to worry about.
Okay. And at some point, were you contacted by an investigator in the mortgage and deed fraud section?
Yeah.
And based on the conversation that you had with that investigator, did you have some further concerns?
Yeah.
Did you speak to either Kisa or Toya about those concerns?
Nah, after I talked to the detective, I called Kisa and told Kisa to be expecting a phone call from Miss Williams, because they're calling me, talking about, Berwood.
All right. And did, Kisa tell you anything in relation to that property?
She just told me, don't worry about it, it's bypass, like, don't worry about it.
If you believe the property belongs to someone, other than the land bank, would you have paid your money?
No.
I have no additional questions.
Okay, I'll go first. And good afternoon to you. It's Ms. Cheese, right?
Yeah.
So if I heard you correctly, you said at some point in time, you stopped having communication with, did you say Toya?
I stopped having communication with her.
It's Toya?
Yeah.
Okay. And do you know approximately when that was? If you know, you do. You know.
I know.
Yeah, okay, but it's fair to say that the communications going forward, we're not going to be with Toya, but someone else, right?
Yeah, I started doing, the case study.
Okay, thank you. Yes, sir. Okay, And I don't have any other questions for you, ma'am, and good afternoon to you. Thank you.
So, question, prior to this whole deed exchange, you'd only known Kisa for a year perhaps, correct?
Yeah, a few months before.
A few months, not that long, correct?
Not that long.
And ma'am, please understand when I say this, I mean this with the utmost respect. You don't take me as the kind of person that would just take things blindly, is that correct?
No.
Okay. So for example, or hypothetically, if someone came up to you on the street with a watch and said you want to buy a watch, you'd probably say no, correct?
Yes.
Okay. If I could develop this, Your Honor, I think it's actually the crux of everything in this case, so I think it's very relevant. So if I could develop this a little bit further, Your Honor. Most respectfully. I said hypothetically, Your Honor, if I could please pursue this line of questioning. If Your Honor, give me just a little leeway to develop it, I'll come right back to why we're here right now.
Tell me what.
Okay.
Your Honor, the purpose is the credibility of this witness testimony, which I think will be made clear as I develop this a little bit further.
Okay.
Thank you.
And if you continue, if you need to.
So man, again, hypothetically, someone comes up to you on the street and says, hey, you want to buy this watch? You're probably not going to buy the watch, correct? Okay, good. Now, understand something. So your testimony right now is that you knew Kisa for a couple of months, correct?
Yeah.
Okay. And it's your testimony that you're looking for a home, correct?
Yeah.
And it's your testimony today that you're presented with an opportunity to perhaps buy a home, correct?
Yeah.
All right. And without even seeing the home, you give your testimony today, give Kisa $3,000, correct?
Yeah.
Okay. And you got a receipt for that also, correct?
No.
No, okay. No receipt. And any witnesses as to that transaction?
Besides Toya, besides them, no.
Okay, no witnesses, okay. And again.
So just so we understand, the issues and any statements that may or may not come out of her mouth, that they're not used against my brian, I appreciate, right? Because it's a brute issue.
Because the way.
Bruton, Bruton, I think that's how you spell it, Jen. I was drinking tea, I couldn't even talk last week, thank you.
And then after you pay the $3,000, how long, again, just so I'm clear, how long after you pay that money do you go look at the house?
Probably like maybe a week or two.
Okay.
Yeah, probably like a week.
Oh, we get to it, okay, a week or two later, okay. You're not sure, you're not sure, correct? Okay. And surely there was something in your transaction where if you didn't like the home, then you'd be able to give the money, then you'd be able to get your money back, correct?
Right.
And you had something in writing to that effect, correct?
No.
Okay. And so after you see the house, it's your testimony that you saw pictures?
There's pictures up in the house.
Okay, like of family pictures or pictures on the wall or something else?
Family pictures.
Okay, of who?
I don't know if I should answer that question.
Did you recognize the family?
No.
Okay. And the door was open also, correct?
Yes.
Okay. At that point, you didn't say, hey, can I get my $3,000 back, correct?
No.
Okay. And then at some point, it's your testimony, excuse me, and it's after you see it that you get the deed, correct?
Yeah.
Okay, so just a one-time viewing of the home, then you get the deed?
Yes.
Okay. And then you got the keys to the house as well, correct?
I never received the key.
Okay, never received the keys. And again, just so I'm clear again, what time frame was this again when this was happening?
The year is 21.
21?
Yeah.
Okay. So the year is 21 when you're getting the deed, correct?
Yes.
Okay. And you've seen, and the deed that you have in your, I believe it's with you right now, where it's been introduced as an exhibit. Have you reviewed that deed before?
Yes, I have, yes.
Okay. All right. And you'd agree that the deed actually states that it was quitclaimed on April 1st, 2020. Would that be a surprise to you?
That it was written on the deed?
Yeah.
No, it's not a surprise that it was written on the deed.
Okay. And,
Because I read the deed, so I know what the deed says.
right, but again, you didn't get the deed until 2021. The deed states, to your knowledge, does the deed quit claim the property to you?
From the date that I registered it in September, yes.
You,
In
ma'am, you have the
2020.
deed, you have the deed with you right now? Okay, does the deed state that someone quit claim the property to you?
In 2020, it says April.
Okay, exactly, it's 2020, correct?
Right.
And does that deed purport, or does it indicate who is quit claiming the deed to whom?
I don't understand the question.
Sure, so if you look at the top where it says quit claim deed, you have that in your possession right now?
Right.
And then it says below that, it's already exhibits, we can speak about it, you know, as what it states, but it says that known all persons by these present, that Michael Hardman, a single man, whose address is 16157 Burwood Street, Detroit, Michigan, quit claims the deed to a single woman, Asia Cheese. Do you see that?
Yes.
Okay, and then down and further on the document, it states that it was drafted by Michael Hardman, and also that it was notarized, correct?
Yeah.
Okay, and you would agree the purpose of a notary is to give things authenticity, to give things authenticity, correct? Authenticate something, right? Okay, and you would agree, ma'am, that to scratch that. So then, based on what this deed purports to state, Michael Hardman is the one that quit claimed the deed to you, correct?
Yeah.
Okay. So that, okay, fair. And so then, and that's accurate, because that's what states in the deed, correct?
That's what the deed says, yeah.
Okay, all right, good. And obviously you wouldn't have recorded something that wasn't accurate, correct?
I recorded what I was given to me.
Okay, but again, but you wouldn't record something that you knew was fraudulent,
I
correct?
would not have.
Okay, but you recorded this, correct?
I recorded
All
it.
right. Even, and again, it states that Michael Hardman quit claimed the deed to you, notarized by Sarah Martin, correct?
Yeah.
Okay. Now, it's interesting, in this quitclaim deed that we've established, we wouldn't do it if it was inaccurate or fraudulent. It states that it was for full consideration of $3,200, correct?
Right.
Okay, but today you testified under oath that you paid $3,000 to Kisa for the property, correct?
Yeah.
Okay, but this deed reports, so that you paid two different people, in one time, you paid Mr. Hardman $3,200, and then you paid Kisa $3,000? How'd that work?
That's never been attested.
Got it.
She actually testified that she didn't know the people that were actually named only that she received Keith. And then she paid. She's never at any point testified that she paid anybody other than.
And actually, she paid $2,000, keep it another $1,000.
Sure, but with all due respect, on this cross-examination, and I'm developing something that's already been introduced as an exhibit, and the witness is answering my question, so.
She didn't testify to it, but I understand what you're doing.
And she's acknowledging that it's accurate, so that's why I'm cross-examining her.
And that's why I'm objecting, because she did not testify to that.
I can read.
He isn't her testimony.
Your Honor, I can
Okay.
ask another question, no problem. Ma'am, again, you recorded this quitclaim deed, correct?
Yeah.
Again, the quitclaim deed deeding the property from Michael Hardman to you on April 2020, correct?
Yeah.
Okay, and in that deed that you've acknowledged is not fraudulent, correct?
From my knowledge.
Okay, and it states there that it was for full consideration of $3,200, correct?
Correct.
Okay. And not only $3,200, but that it was paid by you to Mr. Hardman to get the property deeded to you, correct?
Yes, when they got it registered.
Okay, good. So then, again, based on this deed then, it indicates that you paid Mr. Hardman $3,200, correct?
Yes, it said that I paid this person.
Okay, good. And then you recorded it, correct?
Right.
Good. Now, to your testimony that eventually you said some neighbors came over, correct?
Yes,
When you're in the property?
we're outside, but I was at the property.
Okay, you're outside the property.
Yeah.
Okay. And how many neighbors came over to you?
Just one.
Okay. And what was that person's name?
I don't know.
What was their phone number?
I don't know.
Okay. And never at any point did it occur to you to contact the land bank to find out who exactly had title to this property that was now coming into your possession, correct?
I never did, the police was contacted.
Okay, all right. You contacted the police?
No, the Hardman, I guess, the Hardman did.
You said you guessed, you don't, so that means you don't really know, correct?
The police.
Okay, which Hardman and when did they contact the police?
It had to, I believe it's his daughter, I don't know if it's his daughter or not.
So you don't know,
but
correct?
His daughter contacted the,
What police department did they contact? Okay, and when did this daughter that you're saying right now contact the police? When did they contact the police?
like, the month.
Yeah, yes, and year.
Okay, it was pretty months, so after it was maybe in October.
Okay, but you
It
don't,
happened at the end of,
ma'am, here's the thing, if you don't.
Objection.
That's fine.
You keep cutting the witness off,
Okay,
so.
I'll
Question,
slow
I
down.
ask that you be allowed to answer the question.
Fair enough. Ma'am, if you don't know an answer to a question, saying you don't know is also an answer, okay? Now, when did this Ms. Hardman call the police?
I don't know.
Okay. And who did they speak to in the police department? If you know. Okay. And again, it's your testimony that you paid an additional $1,000 after the deed was put into your hand, correct?
Yeah, after it was purchased.
Okay. My question was, after you paid the $1,000, excuse me, let me finish my question, please. After you paid the $1,000, you said your testimony under oath today was that then the deed was put into your hand, correct? And now you're saying that that's not what happened, is that correct? Now you're saying, yeah, after it's recorded. So was it after it was recorded or was it?
After I got the deed in my hand.
Okay. And then after the deed's in your hand, that's when you give the $1,000, correct?
Right.
And you got a receipt that time, correct?
No.
Okay. And you read the deed once it's placed in your hand, correct? Okay. So, a couple more questions. In 2021, that's when you're contacted by an investigator, correct?
Yeah. And I don't know which investigator you were talking about, because I was approached by many different people.
Okay.
I don't have the answer to that question.
Good answer. That's a good answer. Now, at some point, did you have an opportunity to speak with an investigator?
I still can't answer that question because I was contacted by multiple different people, so I can't answer.
So, yeah, and you don't know if the people that were contacting you were investigators, if they were family members, if they were.
I can't answer that question.
Good. And, but you know the time frame, though, correct?
I do.
So
Like around like the same, I can't answer that question.
It's like about 2 years ago, right?
Okay.
Couple more questions. I'm legitimately done. You paid $45.10 to register this deed with this quitclaim deed. Is that correct, ma'am?
I believe that's the amount. I'm not sure the amount.
Okay, would it refresh your memory if I showed you a copy of the amount you paid for it? Okay. May I approach, Your Honor? And I'm showing you the documents. Tell me if you understand or excuse me, if you recognize what I'm handing you.
Yeah, the receipt, yeah.
Okay. And you see there's a number that the amount you paid for? Okay, thank you. So then you repaid that amount to record it, correct? Your name is on there, it's Asia Cheese, correct?
Yeah.
Okay. And again, this was September 30th, 2021, correct?
Yes.
All right. And then you resided in the property after that, correct?
Never resigned.
Okay.
I'm sorry, you said never resigned?
Never resigned the property. I never lived in the property. Never moved in the property.
Okay. Nothing further on.
Did you ever pay Michael Hardeman any money for this property?
No.
Did you ever participate in writing up or drafting that deed?
No.
When you received the deed, did you know whether or not did you have any reason to suspect that the deed, might be a fraudulent deed?
No.
Council asked you whether or not you read the deed when you received it. Do you recall that question?
Yes.
Did you read the deed when you received it?
Yes.
Did you have any questions about who Michael Hardeman was?
No, I didn't ask.
All right. Why did you ask?
Because technically I thought that I was pretty much, like I told you before, skipping steps for the deed, for the deed, so I didn't ask a question.
So you thought that you were skipping a process in the transaction?
Before it went on Detroit Land Bank.
And did you, when you saw Michael Hardeman's name on the deed, did you suspect anything?
Not off the hand, no.
When did you begin to suspect something?
Once I started getting approached by the neighbor and then the police officers and then the lady. So once I started getting approached by people, then I started like, okay, what is it? Can't be with it.
All right. And when you first started talking to Kisa and Toya about purchasing that property, was it always the intent that you would get a deed to that house?
Yes.
No further questions.
Based on that line of questioning, a couple follow-up questions. Ma'am, you keep mentioning about the police officer and the neighbor and people coming up to you, and then that's when that gave you the impression that there was something wrong with the deed, correct?
Yeah.
Okay. And ma'am, just so I'm clear, you were contacted first in terms of an investigator or law enforcement, correct?
I don't know if they were contacted.
Ma'am, you'd agree at no point did you contact law enforcement and say, hey, I think there might be an issue with this
I
deed?
never contacted any.
Okay, no further questions.
No questions. Thank you.
Wait always for the outcome where she excused me when she wanted.
Yes. Any objection? No.
Yeah. Okay. So do I leave or do I wait?
It's up to you.
Thank you.
Thank you.
You got the witnesses?
No, Your Honor, if you want no additional witnesses.
You met witnesses?
No.
There.
Your Honor, at this time, if people would make a motion to bind over as charged. I'll reserve
Whoever wants to.
I'll go first, because I'm closer. So Judge, on behalf of Ms. Boyce, I would object to the bind over for the following reason. Let's start with the forger, at his forger count, right? That's what I'm making sure I have correct. So in order to have a forgery count, first you have to show that my client, in this case, Ms. LaToya Boyce, falsely made, altered, forged, or counterfeited the the deed in this particular case, right? And third, that when she or he did this, they intended to defraud or cheat. So in this particular case, the testimony has been that everything directly went from another defendant, not my client, to Ms. Cheese. And as a matter of fact, I asked the question, at some point in time, you stopped having conversation or contact with Ms. Boyce. And the answer was yes, and she had testified, I believe, the same on direct that after a point in time, her communications were not going to Ms. Boyce because they did not work together. Right, and so we were gonna have a causation issue as well. That the defendant intended to do something other than to cheat. So, in this particular case. Also, we're looking at the second count of uttering and publishing. First, that the document in question was false, altered, forged, counterfeit. That's up to the prosecution in this particular case. Second, that this particular defendant, my client, represented by words, actions, that this was a genuine document. The testimony was that as far as the uttering and publishing, the document did not come from Ms. Boyce. Ms. Boyce never received any money. Ms. Boyce never gave any money. So anything that happened in this particular complaint does not have anything to do with Ms. Boyce directly. And so here's what's interesting about the uttering and publishing, that when the defendant gave a piece of paper or document, whatever, he or she knew that the document would have been false or altered, forged, or counterfeit. The record is void as to anything and any kind of conspiracy. It's not been set up between Ms. Boyce and the co-defendant on this particular case. You have to have the conspiracy set up before you get into anything that's together. So far, it does not seem to be that for Ms. Boyce. So I would object on the basis of what I put on this record. And thank you, Judge. We would object to the bond. Hold on, let me just see if there's anything else. Thank you, that's it.
Thank you, Your Honor. There are a couple things. First of all, as this court is well aware, granted, it's only a probable cause standard, but Your Honor, I don't think there's a chance in planet Earth that a Wayne County jury or any jury for that matter would ever find even a drop of it or the sufficient amount of credibility necessary to assess this witness testimony, Your Honor, and ultimately get a conviction, so to speak. But specifically, Your Honor, this witness testified under oath, again, Your Honor, that she wouldn't submit a document that was fraudulent or whatever the case might be, or that didn't look right. Her testimony, Your Honor. While at the same time, we understand that she submitted a document that clearly states that Michael Hardman quitclaimed the deed to her for $3,200, notarized. That's a blatant contradiction, Your Honor. Again, she's saying I won't submit a document that's fraudulent. Ma'am, the document says that Mr. Hardman quitclaimed the deed to you. And she testified that she's never seen Mr. Michael Hardman apparently. So that's issue number one, because again, that's the heart of this case, Your Honor. Moreover, Your Honor, just assessing the overall credibility, it's very interesting. She admittedly under oath knows my client for a couple of months, and she's gonna just give my client thousands of dollars without a receipt or anything to verify or confirm that this is actually a legit transaction. She testified under oath that she wouldn't just buy a watch from somebody on the street because she's a cautious consumer, so to speak, right? And then not to mention, Your Honor, all these people that she's discussing as far as they came forward, she can't say any names about anything, Your Honor. And that's what's most interesting is that the person whose name is all over this is Asia Cheese. Asia Cheese recorded the deed. Asia Cheese's name is on the recording of the deed that as the one recording. Asia Cheese's name is the one on the quitclaim deed being the recipient of this property. So again, Your Honor, here you have a situation where if this was actually as it is purporting to be based on these charges, you would expect to see a lot more evidence in support of that. And you have nothing except a witness who lies under oath and says that things aren't fraudulent, but yet files a deed that's blatantly fraudulent, Your Honor. So that, and based on all the totality of evidence, or really lack of evidence, Your Honor, I understand it's not closing the arguments, but again, even by probable cause standard, the prosecution has not met that burden at all. Most respectfully, Your Honor, I'd ask for that all counts be quashed, dismissed.
the judges indicate that, I believe that there's definitely a probable cause shown to, bind over on each of the counts, for both defendants. The testimony, in this matter from Mrs. Michelle White, who was at the property on, 6157 Berwick Street in the city of Detroit, belonged to her father prior to her father's, dying. That Mr. Hardiman, at the time that the deed was drafted, lived with her, and that the signature that is on the deed is not the signature of her father. She indicated that the name is incorrectly spelled for her father. She indicated that she is unaware or unfamiliar with any of the individuals named on that deed, including Adrian Cheese and the notary, Sarah Martin. The deed was recorded with the Register of Deeds on September 30th, 2021, and Mrs. Cheese indicated that she's the individual who recorded that deed. She also indicated that she did not draft the deed, but that she received the deed from Mrs. Keisha Marshall. She indicated that she worked with both Keisha Marshall and LaToya Boyd for a short period of time. And during that period of time, they became familiar with her life, her personal life, and her situation and her need for housing. That both LaToya Boyd and Keisha Marshall indicated to her that they basically knew someone at the Detroit Land Bank and could help her with getting a property. That these were conversations that were had by herself and both defendants. She indicated that at all points, when she paid the money for the property, it was always the intention that she would receive the deed to this property. So when these conversations are first initiated about the property and about the sale of the property, there are both defendants that are involved in this transaction. She indicated that she went to the house after paying the $3,000 directly to Keisha Marshall. She went to the house with both defendants to look at the house. And after she looked at the house with both defendants, she then paid an additional $1,000 to Keisha Marshall. That she ultimately received the quitclaim deed from Keisha Marshall. And that shortly after going back and forth to the property, she became aware that she might not be the actual owner of this home. That she then contacted Keisha Marshall, who indicated to her that everything was okay, there was nothing wrong with it. She also indicated that she initially was told by both Keisha and Toya that everything with the house was okay, that I guess everything would just work itself out. So I believe that the evidence shows, for probable cause purposes, that each of the counts, forgery of a document, uttering and publishing of false pretenses have been met. She indicated that at the time that she paid her money to the defendant, that she believed that they had a legitimate claim to transfer this property to her. And so I asked for a bind over as charged.
Okay, I will not go through all the testimony again. I do believe the people have met the burden of proof for all three charges. With Ms. Marshall, they do partially aiding and abetting theory as Ms. Marshall was not the one, excuse me, Ms. Boyd, defendant two, was not the one who actually received the payments, and was not what I would call the leader of what I think to be a scam here. For count one, forgery of document affecting real property, there's testimony that there is a document, a deed in this case, that was altered or forged based off of testimony from Ms. Whiters. That she said that the signature on that deed was not her father's signature, she was familiar with it, and the name was not spelled right. Second, that the defendant altered or forged this document. And forgery includes any act which falsely makes an instrument appear when it's not. I believe it can be inferred that this document was altered and forged.
as they were the ones who presented it to Ms. Cheese, and it's not the document, or it was not actual signature of the owner, original owner of the house. Third, that when the defendant did this, the defendants intended to defraud or cheat. The plaintiff went into Ms. Cheese, in this case, $3,000 plus another $1,000. Two, uttering and publishing first of the document in question in case, the deed, same thing, false, altered, forged. Second, the defendant represented either by words or actions or both that the document was genuine or true and exhibited or offered or presented. In this case, defendant one, once again, Ms. Marshall was the leader here, but they both were working in tandem as Ms. Cheeks testified several times, kept saying they had to be clarification of who was who. And Ms. Cheeks said she worked with both defendants, saw the property with both defendants after paying Ms. Keisha Marshall $3,000. And then paid another $1,000 to Ms. Keisha Marshall after the deed was provided. And there were issues or questions that Ms. Cheese brought to who she testified, both Keisha and Toya, and was told that it would be okay. And Ms. Keisha and Toya both told Ms. Cheese where to record the deed. So I do think they were working in tandem. And for false pretenses, first, that the defendant used the pretense. And in this case, that they could sell her a house from the land bank. Second, that the defendant knew that the pretense was false. They knew that that house was not something that could be sold because it did not belong that it belonged to. Third, that at the time that they used the pretense, they intended to defraud and cheat Ms. Cheese on $4,000. Fourth, that another person, Ms. Cheese relied on the defendant's pretenses or pretense. Fifth, that by relying on this pretense, the person suffered the loss of something, $4,000. Sixth, that the amount lost had a fair market value at the time it was taken up. In this case, $1,000 or more, but less than $20,000. So I will have both defendants found over for the arraignment information will be May 22nd, since we're both out of custody. 9 o'clock, May 22nd, Monday, May 22nd.
And of course, Judge, you don't object on the aiding and abetting theory, but that's okay. Judge, I'm not sure what the current bond is, but I'd ask that if there is not a no contact provision, that be added to both conditions of bond.
No contact with
No
Ms.
contact
Cheese.
with Ms. Asian Cheese or the property located on Birdwood, but specifically Ms. Asian Cheese.
Yeah, I think it's already a condition.
Okay, I'll make sure that it is.
Thank you, Judge.
And it'll be 9 o'clock on May 22nd.
May 22nd, thank you.
And I'm not sure if it's on Zoom or in person.
We
I
don't
have
know
control
either.
over that.
We don't need it, Judge.
Thank
Okay,
you.
I'll talk to you.
Thank you. Have a good rest of your week.
Goodbye, everybody.
Goodbye. Yes,
Goodbye,
14.